None appears. Dismissal on possible.
Supplementary list item number 19.
I am appearing for the opposite party.
Mr. Venugopal is normally here. We'll pass it over.
Supplementary list item number 20.
My lord, I appear for the petitioner. Through VC, my lord.
Who's for the opposite party?
I am for the.
Huh.
My lord, I have received the counter on 10th of May. But I'd like to move with the arguments, my lord. If it's necessary, I would file a rejoinder if my lord is not convinced.
What is your objection, sir?
My objection, my lord, is threefold. First of all, the agreement has not been stamped at all. And the second one is, my lord, the prerequisite for a amicable settlement as provided and envisaged under the Arbitration Act, that has not been taken place. So there is no cause of action for appointment of arbitrator. And thirdly, my lord, the clause specifies that if the arbitration for the conciliation fails, then the association.
No, are you prepared to go for a mediation right now? We can send both of you to mediation. Why don't you try mediation once?
One thing
My
you
lord.
also can do, leave it open to the arbitrator to decide all these issues along with other things.
All
My
right.
lord, you may-
All right.
Yes, my lord. My lord. My lord is,
Leaving open all the contentions of the parties to be urged before the learned arbitrator in accordance with law, the court appoints. What's the value of the claim, sir?
It is
my lord, current is 57 lakhs.
57 lakhs, I will be also having some.
And I would add, then there would be, I'll be adding some amount of it, my lord.
Do we have a senior advocate?
Senior advocate.
Yes, my lord.
May I suggest the new senior advocate, Mr. Santanu Sarangi's name?
All right, Mr. S.K. Sarangi, senior advocate, is appointed as sole arbitrator to adjudicate the dispute with the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the arbitration center. All right.
You'll also may clarify that whatever contention I've made in this petition shall also be considered.
That's right. You say including the applications.
Made in the objection made in the counter.
Yeah, all contentions of the parties, including those raised in the present petition. Yeah.
Petition
And the reply. And the reply. All right.
Obliged. Obliged.
My lord.
Supplementary list item 21.
My lord, I appear for the petitioner my lord, on virtual mode,
Yes.
where there is a section 29A application by the claimant and
Right.
a section 1415 application by the respondent in the arbitration proceeding.
Right.
My lord, the pleadings were completed on 23rd of November 2019.
Right.
And after clampdown of the lockdown, as your lordships know, the Supreme Court has, my lord, deleted the period up to 28th of February 2022.
Right.
Now, this was done, my lord, after my section 29A application was filed.
Right.
So, I personally feel, subject to your lordship's consideration, that I am now within the period of limitation.
Okay.
But my learned friend, my lord, has filed an application under section 14 and 15, which may require, subject to your lordship's correction, some hearing. So, I leave it to your lordship, my lord, if your lordship may kindly.
So yours, I will say, it's not pressed for the moment. Your petition, I will say, it is not pressed for the moment.
29A.
Yes.
She may record that, and my lord, I don't think. we have any-
Counsel for the Mr. Datta, learned senior counsel for the petitioner, informs the court that in view of the orders passed by the Supreme Court of India clarifying the extended limitation period during the COVID-19 phase, the arbitration proceedings would still be within the limitation period, and therefore he does not press this petition. This is arbitration petition 2 of 22.
Yes.
All right. Counsel for the petitioner, Union of India, seeks and is granted time to file rejoinder before the next date. There's a deficit court fee of 488, which has not been paid.
Yes, so I'll come.
The deficit court
I've
fee
already
also
paid.
paid.
The Kasab is there, you will take care of it.
All right. List
But only
on.
one request, my lord.
Yes.
My lord, if your lordship kindly mentions the date of the order of the Honorable Supreme Court, which is dated 10th of January 2020.
All right. By virtue of the order dated 10th January 2022. All right.
I'm grateful.
And this you say 22nd July.
Very good.
All right.
One pass over. Supplementary list passed over matter item 19.
My lord, interim order to continue, my lord.
Interim order to continue. All right.
Pardon, my lord. Item 9, my lord. इसके संग died, my lord.
I know, but somebody should make arrangements for that.
My lord, 5 minutes late, my lord.
Sorry?
5 minutes late.
No, you argue. No problem.
My lord, adjournment.
No, for what? You are appearing for whom, sir? The petitioner.
My lord.
Why didn't you argue?
File not with me.
Sorry?
File not with me.
What is your name, sir?
Yes, not.
Yes, Nath. Your name is there on the list.
After vacation, my lord.
Sorry?
After vacation, my lord.
All right. Later, Mr. S. Nath appears in 6th time. That is request list on 15 July.
My lord.
All right.
Yes.
Yes.
19.
May it please this honorable court. Well, this is an application for appointment of arbitrator.
Right.
The only defense which has been taken in the counter is there is no signed written agreement. I'll show by the purchase order the terms of the arbitration clause are incorporated.
You can always take these objections in the arbitration.
So this is similar matter which my lords have rejected one petition, same matter.
Oh, I see. Today which I rejected.
Yes.
Oh,
Same clause. You lords can see the prayer. He has prayed for appointment of arbitrator with reference to the tender call notice.
oh.
My lords, I'll show in the purchase order the tender terms have been incorporated, my lords.
All right, let's see that.
Let's come to page 22. May see the bid reference number. It's crucial here.
Yes.
And the next to page 24, which says the bid document contains the following: section 6, general conditions of contract, my lords. And then at general conditions of contract begin at page.
No, but you've not been awarded the contract.
I have been, my lords. I have been issued purchase order pursuant to that. Make see page 130.
So that's a distinguishing factor then, because in the case which I dismissed today, no purchase order was issued.
No, here you also can see page 81. Page 88, sir. Page 88, clause 6.25. The notification of award, letter of intent. Before expiry of the bid validity period, the tender inviting authority will notify the successful bidder in writing by registered post or by fax or email by conference so and so, which have been selected by the tender.
No, so this stage is before the purchase order is issued.
Yes.
He says its purchase order already been issued.
No. Purchase order, he has to sign the agreement. That is the
My lords,
consequential
may
action.
see page 138. I have signed the agreement in the template, which is provided in the tender document, and given it to the department. They have not signed it, but despite that, my lords, at page 143, they have issued the purchase order. And may see the purchase order also. At the top in the reference, it's given bid reference, which relates to the tender notice, and clause 14, which is at page 145. The supplier has to abide by all terms and conditions of the bid reference number. And and my lords, at page 98, in the general conditions of contract, which is part of the bid document, the arbitration clause is provided, my lords.
So here a purchase order has been in fact issued to him.
No, you also can say I have placed 6.25. Then you also can say page 89 clause 6.26. Well, it provides for signing of agreement.
That may be. The question really is, if there's a concluded contract, despite your not having signed an agreement, then why should it not be given effect to?
Well, unless there is an agreement containing arbitration clause, that can be.
No, this makes a reference to the same bid document and says all those conditions will apply.
Provided agreement is executed. That is why I am placing clause 6.26.
Let's see 6.26.
Page 89.
Yes.
Clause 6.2 signing of contract 6.26.1. The successful bidder shall execute an agreement in the format as given under Annexure 4 for ensuring satisfactory supply and after sales support. Then clause 6.26.3. Promptly after notification of award within 10 days from the date of letter of intent, the successful bidder shall execute the
So
contract.
what happens if he's given a purchase order without all of this? Then you will again go after him saying, despite a purchase order, you've not supplied.
He has to approach the civil court.
No.
In fact, my lords, I had approached they invoked my bank guarantee. I had approached this honorable court by way of writ petition. A stay order was granted in my favor, but subsequently the writ was withdrawn with the liberty to invoke the arbitration. The order is at page 155.
All right. All right.
In fact, no liberty was granted. It was given liberty. It is open for the petitioner. When there is no contract at all. And your lordship, I record my objections in paragraph 3 of my counter.
All right. The objection taken by the opposite party to the appointment of an arbitrator is that under clause 6.25 read with clause 6.26 of the tender document, unless a written agreement, public contract is entered into between the parties, the question of invoking the arbitration clause does not arise.
There is also another objection that the purchase order does not contain any arbitration clause.
Further, it is stated that the purchase order does not contain any arbitration clause. Paragraph. However, the court notes that the purchase order makes an express reference to the same reference number indicated in the bid document and states that all the clauses of the bid document would perforce apply to the purchase order. Full stop. The arbitration clause is part of the bid documents. Full stop. Consequently, the court is not inclined to accept the objection raised by the opposite party. Paragraph. Apart from the above preliminary objection, all other contentions by the parties on merits will be left open to be urged before the learned arbitrator in accordance with law. What's the value of your claim?
Around 75 lakhs with interest.
75 lakhs.
My lords.
Should I have a senior advocate?
My lords may appoint.
That's right. All right. SP Mishra,
My lords.
court appoints SP Mishra senior advocate as sole arbitrator to adjudicate the disputes between the parties, including their claims and counterclaims. The arbitration will take place under the aegis of the arbitration center.
Please.
Supplementary list.
Petition is disposed of.
Supplementary list over, special list. Special list for orders item number 1.
Six, 1, 2, and 26. I pray for after vacation, file has been transferred to me.
Not adjourning like this, sir. These are all 2012 matters.
My lord, only my only prayer is that file has been transferred to me last week. I have to prepare. this
No.
case.
I'll help you, sir. Open the paper book, start reading it. I'll help you. We'll read it together.
But I have to prepare one
We'll
senior.
prepare together, sir. No problem.
But in this case, one senior was engaged. And
It's all right, sir. Let us see what the matter is about.
another senior has.
It's all right. It's all right. Let us. I'm not adjourning, sir. I'm sorry, I'm not adjourning.
Last chance will also.
No question.
Also fix a date.
No
also.
question, sir. No question. I'll pass it over. You better get ready with the matter. You seem to be a seasoned lawyer.
Well, I want to engage.
No.
senior.
No, sir, we're not adjourning the matter. Adjournment refused. No problem. I can pass it over. You get ready with the matter and argue. All right.
Also, may take it up the day after tomorrow.
No, sir. We'll take it up at the end of the board. I'll pass it over. You get ready with the matter. 1, 2, and 12.
1, 2, and 26.
1, 2, and 26. Passed over. All right. Yes.
Special list item number 3.
You also may take about this one.
Right away. Good. Come.
Item 1.
Yes. Did you deposit this 2,49,000?
That's it.
Did you deposit as a part of?
Yes. That's it. The original amount has been deposited. And
No, the amount is here pending.
Yes, my lord.
Why has it been kept in a fixed deposit? Just see that.
And in-
Not received. It
And in
says
one
80.
case, and in one case, there are 9 to 10 matters, Lordship. In one case, Lordship, this honorable court has disposed of that the original amount has been taken by the complainant and the matter has been quashed. In one case.
No, but the AD not received from opposite party. Number 2, receipt showing deposit of sum of 22,49 not received.
Item number 2.
No, item 1 also.
One is.
Item 2, 1,50,000, that also not received.
My lord. That amount, your Lordship may give time so that I will try to receive. That it has
No,
been
no.
deposited.
Why should we keep giving time for this? This order was passed in 2012, sir, 10 years
Already
ago.
deposited. Already it is deposited. It's within my knowledge that it is deposited.
No. Otherwise, our registry will not give this kind of a report.
No, your Lordship can direct the registry whether it is deposited. or
No,
not.
we have the note, sir. We have directed, they have a note. It's not deposited. The receipt is not there.
Lordship may have-
Anyway, all these, please, you can take in the trial court.
Yes, ma'am.
You've enjoyed a stay now, sir. You've enjoyed a stay for 10 years.
Yes, ma'am. The case of.
You say reserving the liberty of the petitioner to urge all the pleas urged in the present petition in the trial court at the appropriate stage. The petitions are disposed of, the interim order is vacated. Paragraph, the registry has reported that the demand drafts supposed to be deposited by the petitioner in this court pursuant to the interim orders passed have not yet been deposited, as there is no receipt of such deposit available in the registry. That's it. So 1, 2 and 26.
1, 2 and 26.
All right, sir. All right. Yes.
Specialist item number 3.
May I please, Lordship? My lord, I am challenging the order taking cognizance. The offence alleged is 498A along with the other offences.
All this you can raise at the appropriate stage, sir.
My lord, in the meantime, decree of divorce passed, my lord, I have enclosed that is under annexer 4, my lord, your
You
lordship.
can point it out to the trial court, sir. You point that out to the trial court. You say the counsel to petitioner points out that a decree of divorce has already been passed in the matter. It will be open to the petitioner to bring this to the notice of the trial court when the matter is taken up there. The interim order is vacated, the petition is disposed of.
Specialist item number 4.
May it please your lord's my I am in Vishi mode, my lord.
Yes.
My lord may see my lord's order dated 22/4/2022.
Yes.
That case, my lord, where I draw my lord's attention to a judgment of 2020. My learned friend appearing for the state draws the attention, my lord, to judgment of 2012. And my lord was, but 2020 has taken note of an earlier judgment of 2011. So my lord put this question to me.
Yes.
My lord, in paragraph 2, my lord may kindly see.
Yes.
Two judgments of the Supreme Court of the same bench, strength of 3, one state NCT of Delhi versus Ajay Kumar Tyagi, 2012 SCC 685, taking the view that despite the exoneration in departmental proceedings, criminal proceedings can continue, and other, that is Ashu Surendranath Tiwari versus Deputy Superintendent of Police EOW CBI 2020 volume 9 SCC 636, taking the opposite view, that is the once is departmental proceeding a person is exonerated, then on the same state of criminal prosecution cannot continue. However, the decision in Ashu Surendranath Tiwari makes no reference to the earlier decision of state versus Ajay Kumar Tyagi. It, however, refers to the decision of Orissa Kejriwal versus State of West Bengal in 2011, volume 3 SCC 581, where 2:1 majority of 3 judges bench of the Supreme Court was of the views similar to one taken in Ashu Surendranath Tiwari. It may be noted here that the decision of Ajay Kumar Tyagi makes no reference to the decision of the coordinate bench of Radheshyam Kejriwal, and my lord was pleased to direct me to address the court. My lord, I have given a short note that must be with my lord's.
Yes.
And I have also given a copy to my lord and friend.
Yes.
My lord, may I read the note, my lord?
Yes. Yes, Mr. Das.
My lord, may I read the note, my lord? I have tried my best to explain everything. The present short note is being filed by the petitioner to address this honorable court on the limited aspect of concerning the position of law as regards to the operation of law with respect of 3 separate judgments passed by the coordinate benches of the Honorable Supreme Court of India of equal strength, which have decided the same point of law. That is, exoneration of the accused in departmental disciplinary proceedings having occasion, criminal proceedings based on the same set of facts should be allowed to continue or not. Whether such proceedings should be an abuse of the process of court and wastage of judicial time. My lord, I have quoted all the three judgments, 2011, 2012, and 2021, which is also reported in 2020 SCC, my lord. My lord, got it?
Yes, yes.
The judgment in Radhesham case with a majority of 2:1 had referred to various two-judge bench decisions of the Honorable Supreme Court, and after going into detail and discussion, had laid down certain criteria regarding adjudication proceeding with service criminal proceedings at paragraph 38 of the judgment. That paragraph 38.
That's Radhesham Kejriwal.
My lord, my lord. My lord, I have tried my best, my lord, to quote 38 and 39 of Radhesham Kejriwal's judgment, my lord, which has been taken note of in 2020 Supreme Court by Honorable Justice Lalit, my lord. My lord, we see page 3, capital B. The judgment of Ajay Kumar Tyagi, by which my learned friend submitted 2012, was passed by a bench of 3 judges, and the said issue came for consideration before the 3-judge bench due to conflict between 2 decisions and entered by the 2-judge bench of the Honorable Supreme Court, wherein the issue in contention herein was decided.
Mr. Dalal, the fact remains that Ajay Kumar Tyagi makes no reference to Radhesham Agarwal.
Yes,
Kejriwal.
that has been taken note of in 2013 Supreme Court 3588, a situation of the present time. And let me kindly see 2013 Supreme Court, State of Assam versus Ripa Sharma.
See, only difficulty is both Ashu Surendranath Tiwari makes no reference to Ajay Kumar Tyagi.
And that I want to
Ajay Kumar Tyagi makes no reference to Radhesham Kejriwal.
Under
So,
these circumstances,
the score is 1 each.
Yes, under these circumstances, 2011 Supreme Court will be taken note of. If by the 2013 Supreme Court page 3.
See, the only thing is Ashu seems to be the last of the judgments.
My lord.
Yes.
And
So,
my lord, I have.
in terms of chronology, Ashu is the last.
Yes.
Ashu is the last. And if my lord will follow 80 Karnataka full bench, Gujarat full bench, MP full bench, the last decision will be taken note of. That is, my lord, that I have.
Let me hear Mr. Das.
Yes, Lord.
Yes.
Lord, the exact issue, Lord. The Asu case and Radhesham Kejriwal and Ajay Tyagi case. In fact, after the delivery of Asu judgment, my lord, the Kerala High Court and Jammu Kashmir High Court, my lord, the same issue was raised for those 2 high courts, my lord. Whether which judgment is to be followed, my lord. I'm just
All right.
Lord, may kindly see first the Kerala High Court judgment.
Right.
Lord, my lord, I've just handed over my copy, my lord.
Right.
Lord, may kindly just Lord, me just written my copy. I have marked those paragraphs.
That is reported in.
Lord, see paragraph 9, my lord. May I read it?
Yes.
Learned Senior Counsel has submitted that departmental inquiry in the matter was conducted against the petitioner and he was exonerated of the charge framed against him in that inquiry. Learned Senior Counsel would contend that once a person is exonerated of the charges in the departmental inquiry, criminal proceeding against him on the same fact shall not be continued.
Oh, so he says in all the,
yes,
he goes by the opposite principle of earliest.
Yes, my lord.
And he says everything else is per uncarium.
Yes, I think at paragraph 25, if you lordship will see.
That's what.
Yes,
This court has no hesitation to follow Tyagi and to hold the exoneration of a person in department would not ipso facto lead to exoneration of a criminal.
yes, my lord. Lord, I am just handing over the Jammu Kashmir High Court judgment.
But he's got 3 full benches, he says, of high courts, which
full
hold the opposite view.
I have stated in paragraph page 4 of my note, my
Lord, if your lordship will see,
page 4
Jammu Kashmir High Court,
of my judgment.
he has relied the 5 judge bench judgment of Supreme Court, where they say the previous first judgment will prevail. My lord.
My lord, that is also the view. But 2011 will be taken note of. Another important thing, my lord.
Lord, your lordship kindly come to paragraph 15 of Jammu Kashmir judgment, Jammu Kashmir High Court. From careful analysis.
One thing I want to say, my lord, and friend must have seen that one judgment, my lord, P.S. Rajya versus State of Bihar.
Correct.
My lord, 96 volume 9 SCC page 1.
Correct.
That has been taken note of in 3 judgments, my lord.
Correct.
And my lord, the view has taken in Rajya's case though has been not accepted in Tyagi's case, but has been accepted in Kejriwal by Kejriwal and Honorable last judgment of 2020 Supreme Court.
But Kejriwal, my lord, my humble summons is 2:1, my lord. So in any.
No,
No, no. It's only
not
over
there.
the
2:1 means.
go by the bench strength, not the.
But my lord,
That is valid decided in 2011.
Yeah, no, that will go by bench strength. Yes.
2018 volume 11
Jammu Kashmir
SSC.
High Court has interpreted. my lord.
2018 volume 11
It's not
SSC
correct, sir.
page 305.
I
Honorable
limit
Apex
my
Court has
lordship,
made
my
it
lord.
clear. Strength is means three judges. One judge
Correct.
deferred means that cannot be. That has been decided in 2018 volume 11 SSC page 305. I have also given that judgment in my note, my lord.
So where are your full bench judgments?
My lord, full bench judgments are, my lord, I have stated in page 4 of my note.
All right.
Catenary decisions have been passed by several high courts of the country where the issues of being confronted by conflicting decisions of the Honorable Apex Court of same strength has been discussed in great detail. They are, my lord, 80 Karnataka 92, AR 86 Gujarat page 81, and 2003 MP page 81.
But what do they hold?
They hold, my lord, the latter judgment will be taken into consideration. Latter means, my lord, to 2020.
All right.
Well, I'll file a written note.
All right. Orders reserved. Mr. Das states, Mr. Dalal, senior counsel for the petition, has already handed over a written note of arguments. Mr. Das, appearing for the state, is permitted to file his written note of arguments within 1 week.
Yes.
All right. Interesting question.
My lord. The point to be decided here, no judgment is, our High Court is there in detail in this.
All right. All
So I
right.
have tried my best to prepare a short note referring.
Yes. 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 All right.
Specialist item number 5.
That interim order will be continued.
Yeah. Interim order to cut.
My lord.
May I please, my lord? This is a case relating to distribution of the case amount leaflets and star in the election of 2009 assembly election.
Is it still surviving? What is this?
My lord,
Why are we still dealing with this matter, sir?
and the petitioner is a driver of the vehicle. He was driving the vehicle at that time, and from that vehicle, the leaflet and 4,100 rupees cash was seized, which was kept.
What is UI meaning?
My lord,
UI number 301. What is UI?
my lord, it is proceeding case number UI.
What does it stand for? What is U? What is I?
Unimportant case.
Huh?
Unimportant case number. UI case.
Unimportant case.
My
Unimportant.
lord.
Are you serious or you actually saying it is unimportant?
Yes.
UI means unimportant. That's very strange. Oh, I see. UI means unimportant. Why is it unimportant? It's making him come with a revision here, getting a stay here. Yes.
The petitioner is the driver of the vehicle, Commander Jeep.
All right.
At that time, some rupees.
It's okay. All these pleas can be taken in the trial courts.
Yes.
Permitting the petitioner to urge all the pleas taken here in the trial court at the appropriate stage, the petition is disposed of. The interim order is vacated. All right. The intimation be sent to the concerned court forthwith. Everywhere, wherever vacating, say, intimation to the concerned court, not authority, concerned court.
Specialist item number 6. Item 6.
None appears dismissed, not opposition. The interim order is vacated.
Specialist item 7.
I believe. Please.
I am challenging the cognizance taken by magistrate under section 3 of SCST Act. Two illegal issues are involved in this case. Whether the magistrate has any power to take cognizance under section 3 of SCST Act. Second point, here is that whether magistrate can take cognizance without directing the police, not less than a DSP, to investigate the matter under section 156(3) of CRPC. That is the main issue involved in this case. Can I have a glance? I have already
Page
filed-
13. Let's see page 13.
Yes.
Where has he directed investigation? He doesn't seem to have directed any investigation by anyone, sir.
No. So it is out of a complaint case.
Correct.
Complaint case. So when he is taking a cognizance under a serious offense like a 3 SC Act, he cannot take cognizance directly without directing the police below the rank of a DSP to investigate the matter as the rules envisaged. Can I have a glance? What is the rules? Sir?
My lordship, 204 that.
And I have glance. SC/ST Prevention of Atrocities Act rules 7. An offense committed under the act.
You have to have some patience. Either you give me the book or let him take out the book.
Oh, sorry.
Fine.
Which rules are you reading?
SC/ST Prevention Atrocities Rules 1995.
Yes.
Yes.
And
Section 7.
Rule 7.
7. Yes.
Right.
Yes. An offense committed under the Act shall be investigated by a police officer not below the rank of a deputy superintendent of police. That is the mandate of rule.
No, but why should this investigation not happen after taking cognizance? He's only taken cognizance.
He has already taken cognizance and issue process in favor of me, against me. So my submission is that as is the special court.
This is a complaint case, sir. This is investigation is by the on a complaint to the police. This is a complaint case to the court.
That
complaint under section 202. So this is a complaint under section 200 CRPC.
Yes, fine.
So if it's a 1cc case, do you have any judgment here?
Lord, on last date, I was telling that the learned senior counsel was pressing that the magistrate doesn't have the authority to take cognizance when a CXT Act is involved. Lord. I have just cited one judgment, the recent judgment.
The recent judgment has come.
The Supreme
Recently
Court,
in 2021, the magistrate can take cognizance, but it is a pre-amendment under different circumstances.
No.
The Act was amended in 2016.
This is a 2010 case.
Yes. The decision relied upon by current council is of 2021. It is a case in 21. In pre-amended, the cognizance can be taken by the magistrate. That is the ruling of the Supreme Court. But it is a case before 2016. My humble submission
also before 2016.
Yes. My submission would be it is covered by a Gangula Osaka case and our class. Supreme Court. Without commitment by the magistrate to the special court, he cannot take a cognizance. The special court functioning under section 14 of the Act has a power to take cognizance.
So what do you say to this Gangula Ashok?
Lord, I have
It
not
has to be
gone-
committed to the special court and only the special court can take cognizance.
My lord, since my learned senior is talking about pre-amendment, because the offense is now above prior to 2014, my lord. The judgment I have guys even just now provided, my lord, paragraph 25 deals with the pre-amendment provisions, my lord. Paragraph 25.
25.
Yes. This court had an merit. This court had an occasion to consider section 14 pre-amendment in the case of Ratiram. In the case before this court, which was pre-amendment, the learned sessions court straightaway took the cognizance. This court considered section 193 of the Code of Criminal Procedure and formulated the questions whether the special court as constituted under the Atrocities Act is a court of sessions and whether there is a constitutional provision in the act enabling the said court to take cognizance. This court, after taking note of section 193 of the Code of Criminal Procedure, observed that on plain reading of section 193 of the Code of Criminal Procedure, it is clear that no court of session can take cognizance of any offence as a court of original jurisdiction except as otherwise expressly provided by the court or by any other law for the time being in force. At this stage, it is required to be noted.
So anyway, sir, even in the pre-amendment,
My lord,
the question of magistrate taking cognizance did not arise. He had to commit it to the Court of Sessions and then the Sessions Court could take, as a special court, could take cognizance.
my lord.
So either way, even if you go by the pre-amendment, this order is not sustainable.
But there is one provision under
So this has to go back, the order will be set aside, to go back to the magistrate and then he can commit it to the special court.
Right.
You say the challenge in the present petition is to an order dated 15th July 2011, passed by the learned subdivisional judicial magistrate Khurda, taking cognizance of the offences, inter alia, under section 3 of the Scheduled Caste and Scheduled Tribe, bracket Prevention of Atrocities, bracket Act 1985, bracket TOA Act, bracket, in 1 CC case number 401 of 2010. While directing notice to issue in the present petition on 28 November 2011, this court granted a stay of further proceedings in the aforementioned case before the SDJM Khurda. Paragraph, this court has heard learned counsel to the parties. Full stop. As explained by the Supreme Court of India in Gangula Ashok versus State of AP 2000, Criminal Law General 819, bracket SC. Even the special court under the POA Act cannot straightaway take cognizance. The case has to be committed to it by a magistrate, and then the special court has to apply its mind on the question of taking cognizance. Paragraph. Learned counsel for the state has drawn attention of the court the recent decision in Shantaben Burhabai Bhuria versus Anand Attabai Chaudhary 2021 SEC Online SC 974, where the Supreme Court has explained at great length the position that existed prior to the amendment to the POA Act. In which year was that amendment?
2016.
2016.
Yes.
And the position thereafter. Paragraph. On perusal of both judgments, it appears to the court that in the pre-amendment stage, which is what the present case is about, bracket, no magistrate could have straightaway taken cognizance of an offence under the POA Act. The magistrate would have had to commit the case to the special court, which would then consider the question of taking cognizance. Even post 2016 amendment, the question of magistrate straightaway taking cognizance of offence under the POA Act does not arise.
Post, the Supreme Court says that post amendment, the magistrate can take the cognizance.
Which paragraph?
Paragraph 9.2.
Sorry?
Paragraph 9.2.
No.
9.2? I'm on Shantaben Burabai.
Yes.
Yes.
Bhuria.
Shantaben.
para 26. Get up to the- para 30, para 30, 30.
My lordship, shall I interrupt my lordship? Apology, my lordship. My lordship, I am appearing from the opposite party number 2, my lordship. My ignorance, my lordship. In that case, my lordship, item 7, my lordship.
Para 30, in support of the above, may I read? In support of the above conclusion, the words used in second proviso to section 14 are required to be considered minutely. The words used are court so established or specified shall have power to directly take cognizance of the offence under this code. The word only is conspicuously missing. If the intention of the legislature would have to confer the jurisdiction to take cognizance of the offences under the Atrocities Act exclusively with the special court, in that case, the wordings would have been that the court so established or specified only shall have power to directly take cognizance of offence.
Correct. In the post amendment to section 14, as explained by the Supreme Court in Shantaben Burabai Bhuria Supra, it is open to the magistrate to take cognizance and then commit the case to the special court. Paragraph. In the present case, since this pre-amendment, in terms of the said judgment, the impugn order passed by the magistrate dated 15 July 2011, taking cognizance of the offence under section 3 of the POA Act, is hereby set aside. And to that extent, the matter is remanded to the SDJM Khurda for proceeding with vis-a-vis the said offence in accordance with law.
Just pointed only one thing, Lord. The Lordship may kindly, if the CRPC that section 460, it says the irregularities which do not vitiate proceedings.
No, SC/ST Act is a special
Act. But in
the order be sent to the concerned court of the SDJM forthwith. The petition is disposed of in the above terms.
Specialist item number 8. Item number 8.
None appears dismissed on prosecution.
Specialist item number 9.
May I please, your lord?
Yes.
My lord, here, there is the petitioner is the husband and the OP number 2 was the wife. My lord, there is a development in this case that in the meantime, the divorce proceeding has culminated in the Honorable Apex Court. They have finally the divorce.
Pointed out to the trial court.
But here, my lord, will see a cognizance has been taken against me under section 341, 323, 506 and 379 on the allegation of the wife that case was pending in Cuttack. Parties were contesting in Cuttack. The wife had come to Cuttack and deposed on that day. On the return, she files a 1cc case saying that when she was getting got alighted from
She
the
may not
bus-
even appear there, sir. Your problem will be solved.
Yes. As you're not sure
Counsel for the
that
petition-
liberty
yeah.
to raise all these
Correct.
points.
Counsel for the petitioner points out that there has been a subsequent development in as much as the divorce between the parties has been affirmed by the Supreme Court of India.
Yes.
It will be open to the petitioner to point this fact to the trial court at the appropriate stage. Liberty is also granted to the petitioner to urge all the contentions raised in the present petition before the trial court at the appropriate stage.
Bless.
With the above observations, the interim order is vacated and the petition is disposed of. Information will be sent to the concerned court.
Item number 10.
None appears dismissed on prosecution. The interim order is vacated. Same thing.
Specialist item number 11.
Next sitting.
No, what is it, sir? Let us see what the matter is. Come.
Misplace the file if you also will permit me the.
Take the file from us. 1cc case.
Pass it over and go, just go into
Or pass over.
Specialist item 12.
Not pressed, disposed of. Interim order is vacated.
Specialist item number 13.
Becoming so Krishna.
Council petitioner stays to become in practice. The interim order is vacated. Or it's disposed of.
Specialist item number 14.
14 may I please I'm in virtual mode Lordship.
Yes.
In this case my Lordship, that I only pray before Lordship, I will find an affidavit before my Lordship, my Lordship. Give me some time, my Lordship.
No. What is it?
My Lordship, is a case of the FIR has been annexed in Annexure 1, my Lordship, is a case of 363 and 366A and 34 IPs, my Lordship. In that case, the present petitioner had married with the opposite pen number 3, my Lordship.
You can point that out to the appropriate court, sir. It is stated that petitioner is now married, opposite party number 3. This development can be brought to the notice of the concerned trial court at the appropriate stage, permitting the petitioner to raise all such contentions, including the ones raised in the present petition before the trial court at the appropriate stage. The petition is disposed of. The interim order is vacated. A copy of this order be communicated to the concerned court forthwith.
Yes, my Lordship.
Item 15.
Not pressed, disposed of. The interim order is vacated. Yes.
Specialist item 16.
Item 16, my lord. It is similar, item 16 is similar to item number 7, my lord. Here, annexure 1 was the cognizance taken by the magistrate under the SC/ST PO Act, my lord. That is prior to the amendment, my lord.
All right. The magistrate here, Judicial Magistrate First Class Salipur, has in GR case number 244 of 2010 taken cognizance inter alia of the offence under section 3 bracket 1 bracket small Roman 10 of the SC/ST Prevention of Atrocities Act in terms of the judgment in Shantaben versus
Anand Athabhai Chaudhary.
Anand Akhavai Chaudhary. 2021 SCC online.
Supreme Court 974.
Supreme Court 974. It is plain that the magistrate could not have straightaway taken cognizance when the amendment to section 14 had not of the POA Act had not yet been carried out. The magistrate should have committed the case to the special court. On that short ground, the impugn order is set aside. The case is remanded to the JMFC Salipur to be proceeded afresh in accordance with law. The petition is disposed of.
Specialist item 17.
I will humbly draw your lordship's attention to the order dated 16/5/2012. Here, this honorable court had directed, in view of the submissions made, the petitioner is directed to produce OP number 2 before the concerned IO within period of 2 weeks from today, who shall produce her before the JMFC Jaleshwar for recording her statement under 164. The learned magistrate is also directed to send the statement recorded immediately to the registry of this court for consideration in the present case.
Has that happened?
Well, whether that report has come or not?
Yeah, we'll just see. Flag I. Flag 1. So the petitioner did not produce the order of this court, sir. He never produced the order of this court before the concerned JMFC Jaleshwar.
No, the girl.
So that statement could not be recorded. This is a 2012 report. Now you can go before that court.
Yes, your lordship.
You say, despite the order dated 16th May 2012 of this court in the present petition, from the report of dated 8 July 2012 of the JMFC Jaleshwar, it appears that the said order of this court was not produced before the JMFC, Jaleshwar, for the statement of the opposite party number 2 to be recorded under section 164 CRPC. Paragraph. Nevertheless, since Mr. Bose maintains that the petitioner and opposite party number 2 have been married for over 11 years now.
Yes.
It will be open to the parties to appear before the GMFC and make the appropriate submissions in accordance with law. The interim order is vacated, the petition is disposed of. A copy of the order be sent to the GMFC concerned.
Obliged. Specialist item 18.
18, my lord. I have no instruction. If the cause of action survives.
No cause of action, sir. 2012.
My lord, I am not praying for Passover or.
No. You say counsel the petitioner state
I
has no
have no
instructions.
instruction. Your lordship may can dispose of with a liberty.
Disposed of. There's no liberty in also. Disposed of. All right.
Specialist item 19.
Interim order is vacated. All that. None appears dismissed for non-prosecution. The interim order is vacated.
Specialist item number 20.
None appears dismissed for non-prosecution. The interim order is vacated.
Specialist item number 21.
May I please, your lordship?
Yes.
My this is an application for quashing. My lord, the FIR was lodged against the petitioner and others. My lord, for commission of offences under section 395, 379, 363 of the IPC and section 9B of the Indian Explosive Act. Your lordship, a bare perusal of the FIR shows the parties are of the same locality and they had some kind of dispute, though offences as it appears has been given as if it's a case of dacoity and other offences. Be that as it may, my lord, the matter was supervised by the SDPO during the course of investigation. Your lordship may kindly turn to page 5 of my petition, paragraph 5.
Yes.
On supervision, the SDPO says that neither the complainant nor the witnesses have prima facie established the case so far as the petitioner is concerned. And SDPO gave a report to that effect during the course of supervision, and despite that position, the charge sheet was submitted against the petitioner. And that is how cognizance was taken. Even the complainant also filed an affidavit for the court below saying
You can apply there for discharge or whatever, sir.
my lord,
that remedy is available.
My lord, only thing I beg to submit, my lord, that your lordships have been pleased to hold that even if a remedy of discharge is also available at the stage of.
You've enjoyed a stay, Mr. Mishra. You've enjoyed a stay for 11 years now.
Your lordship may then relegate me to the stage of
Correct.
charge
Correct.
bringing this to the notice. Because the SDPO has said it's not
All
my.
right. Leaving it open to the petitioner to urge all contentions, including those raised in the present petition, before the trial court at the appropriate stage. The petition is disposed of. The interim order is vacated.
Obliged, man. Obliged.
Specialist item 22.
May I please? The order taking cognizance is under challenge, my lords.
You can raise all contentions before.
My lord, the cognizance, its order itself is illegal and without jurisdiction.
All right, shows
in
that.
view of section 195 CRPC, my lords.
Okay, let's see that.
I may be permitted because if your lordship permits, may I place the facts, the prosecution case, my lords.
First, let's see the impugned order.
Impugned order is at page 93.
Yes.
The order dated 5/12/2011.
So you must PC Act. What were you?
My lord, I am they have the prosecution case is that the petitioner was a complainant in a trap case. During trial, he retracted from his previous statements recorded under section 161 CRPC, and he did not support the case of the prosecution.
No, who are you? You are a private individual or a government servant?
I am a private person, my lord. Now, since the entire case of the prosecution is that since I retracted from my previous statement, which and I did not
all these
support
pleas you can take, sir. Before the appropriate at the appropriate stage, you take all these pleas.
No, they have also taken cognizance under section 182 and 211 IPC. It is apparently barred by section 195 CRPC, my lords. Except on a complaint made in writing, so far as 182.
Can you not urge this before the court there? Of course you can urge it, sir. Leaving it open to the petitioner to urge all the pleas raised in the present petition at the appropriate stage before the trial court, the petition is disposed of, the interim order is vacated. Yes.
Specialist item 23.
23, your lordship and disposable to raise all the plea at the time.
Yeah, same order in 23.
Specialist item 24.
Let's item 24 also
Same order, same order. All right.
Specialist item 25.
None appears. This was non-prosecution. Interim order.
Item 25, my lord, during pendency of this case, petitioner was already died.
Okay,
In
counsel
process.
for the petitioner
In
states that the petition is already expired during the pendency of the petition. It is disposed of as having abated. The interim order is vacated.
Specialist item 27. Item 27.
Yes.
I raised all the points at the time of.
All right. Same order as that earlier one. All right.
Specialist item 28.
Item 28, if a lordship may allow a passover matters.
All right. Pass over.
Obliged.
Specialist item 29.
This is a case challenging cognizance arising out of a complaint case under section 138 of the NI Act between the two brothers. The amount has been paid. Only I pray I may be permitted to file a petition before the.
All right. Counsel for the petitioner states that the amount in dispute had already been paid. He is permitted to point this out to the trial court by filing an appropriate application. The interim order is vacated. The petition is disposed of. Right.
Specialist item 30.
May I please, Judge? The unfortunate the doctor, orthopedic doctor, he has been entangled in a case of 304A of IPC.
Yes.
I have annexed the order, my lord.
Yes.
It is a case of the prosecution that the prosecution has already been filed the counter, and the case of the prosecution is like this. The present petitioner who has been appointed in Titlagarh hospital, at that time a patient came and complaining that he has sustained some fracture on his hand. Thereafter, the present petitioner advised for bandage and plaster and advised to take medicine. And thereafter, after 6 to 7 days, he again come forward to the medical, approach before the nurse to inject him, the injection which has been prescribed. Thereafter, he has taken the injection and returned back to his house. And after 8 to 9 days thereafter, my lord, he was suffering pain, and it has been found that after administered the injection, there was some infection for which he succumbed to the injury. This is a sum total allegation which has been advanced on behalf of the prosecution, my lord. So far the present petitioner is concerned, the doctor, a limited role is that the patient come forward and stating therein that I have sustained fracture on my hand. Being the profession, my lord, he has advised to take medicine and to administer the injection and advised for taking the bandage and to plaster. That much allegation against me. Thereafter, the matter has been referred to the CDMO and the higher authority. Whether the injection which has been prescribed and the doctor who has been on the duty, the present petitioner, has caused any negligence in duty. Thereafter, the inquiry has been conducted. CDMO found that there is no negligence, and the committee which has been established under the my lord, the act, my lord, they have opined the injection is meant for pain killing, and it has not caused any negligence act on part of the present petitioner. Rather, the case has been turned to a case of 304A, my lord. The London Court will cheat upon the matter and took the cognizance. In view of the apex court decision, your lordship knows that, and your lordship may kindly see the affidavit which has been filed by the state on 8/7/2015 in the present case. The investigating agency, while shown the affidavit, it has categorically narrated that the NAC is not responsible for the death of the deceased. Only my allegation against me, I have prescribed prescription that to take medicine.
Where is the order taking cognizance?
My lord, that is.
It's 17.
17, my lord.
Let's read that.
Accused is absent, and his advocate files a petition praying to repent him, which is hard and allowed to death, so and so, so and so. Filed from the side of the prosecution, heard the both the prosecution and defense counsel on the said petition. The defense counsel in the aforesaid petition submitted to discharge the accused from the charge level against him and accused him from the aforesaid charges. The London prosecution counsel orally objected to the said petition. On perusal of the record, it is noticed that the case was registered against the Sunil Kumar Fadi on the allegation of the offence under section 304 IPC in the court of the SDM Titlagarh. And the case was committed in the court of the additional session judge Titlagarh. The additional session judge Titlagarh, by order dated frame charge on against the accused under section 304 part 1 IPC and procedure trial. Against that order, regarding the framing of charge under section 304(1) IPC, the accused referred the revision before the Honorable High Court and criminal revision number so and so. And the Honorable High Court allowed the
You
criminal
seem to have
revision.
filed this petition very late, sir.
My lord,
12 witnesses have already been examined.
no, for that reason, my humble submission before your lordship,
3 more witnesses to be examined. That's all.
my prayer before your lordship may kindly see. My prayer before your lordship to discharge the present petitioner by utilizing the power under section 232 of CRPC. Because after adducing the evidence, while it has been come forward, the nurse who has come forward and narrated the entire evidence before the learning court below, while she has adduced the evidence, she has narrated that I have administered the injection. On that score, I have filed a petition for discharge the present petitioner under section 232 of evidence CRPC, my lord. After taking note of the entirety of
Is
the
opposite party number 2 here?
my lord.
Opposite party number 2.
My lord, that is the informant.
Has he been served?
My lord, I have already filed the requisition. And everything is in my favor, my lord. The counter affidavit filed by the State Council, he has supported my case, and so also the nurse who has administered the injection, she has categorically narrated that I have administered the injection after 7 to 8 days. Prescription has been prescribed by the.
Where is that? Where is that?
My lord.
She is already deposed.
She has deposed. In the meantime, she has deposed.
Where is that statement?
That evidence I have not got. I have instructed to my conducting counsel to apply for the certified copy, and also this honorable court directed State Council to
he
file.
seems to have it.
Annapurna Kerketa.
So she has turned hostile.
She was elaborately cross-examined.
Elaborately cross-examined. You see, this is a petition filed challenging an order dated 13th June, sorry, 18th February 2012, passed by the Chief Judicial Magistrate Balange, GR number 508, 2003.
Mela.
Declining the petitioner's prayer for a discharge. Paragraph. The background facts are that the petitioner was at the relevant time an orthopedic doctor. At the, what is SDH? What hospital?
Subdivisional hospital.
Subdivisional hospital, Titlagar.
Titlagar.
Stop. The patient, Sachin Ray, comma, the father of opposite party number 2. Informant was undergoing treatment for fracture of the right wrist. Under one doctor B.B. Nayak. Full stop. On 30th November 2003, in view of the severe pain on his fractured hand, he was advised by the petitioner, whom he consulted, to take NAC injection. Full stop. Later, on 2nd December 2003, the patient was admitted as an was seen as an outdoor patient by Dr. B.B. Nayak and then referred to the district headquarters hospital at Balangir. Where he apparently died due to single quotes gas gangrene. Unquote, full stop. In the inquiry conducted much later on 4th May 2011, by the Chief District Medical Officer, Inquiring Officer Balangir, it transpired that, according to Dr. B.B. Nayak, who was a specialist in surgery, the petitioner had given the right treatment for the orthopedic complaint of the patient. Srimati Anupama Karkata claimed that she did not remember administering the NAC injection to the patient since more than 7 years had elapsed. Full stop. The conclusion in their inquiry was that there had been no negligence, no medical negligence during treatment by the present petitioner. Paragraph. From the impugned order of the learned CJM, it appears that the plea for discharge was based on the above report of the CDMO, and yet the CJM declined the prayer because by then 12 out of 18 witnesses cited in the charge sheet had already been examined. A comment has been made in the impugned order by the learned CJM that, open quotation, the evidence available in the record prima facie bears merit and no materials to discharge the accused, unquote. However, the court has been shown the deposition of Ms. Anupama Karkata, the nurse, who is supposed to have administered the NAC injection. Full stop. It appears that she did not support the case of the prosecution at all. Full stop. She was first examined on 10 June 2009 and then recalled for a further cross-examination on 26 March 2010. Full stop. She clearly denied as under open quotation, it is not a fact that I have stated to IO that on 30/12/2003 I was in duty in the evening and on the prescription of Dr. Sunil Padi, I gave injection to the patient. Full stop. While I gave on the buttock, I have not seen any injury or swelling, unquote. She also denied that she had not sterilized the syringe while giving such injection. Full stop. The long and short of the deposition of Ms. Karkata, one of the key witnesses for the prosecution, was that the petitioner was in no way involved in the actual administering of the NAC injection to the patient. Full stop. The categorical report of the CDMO is that the death was not due to the NAC injection. Full stop. Where is that line? Where? There's one line which says not due to NAC injection, right? Not. Which page is that? An affidavit has been filed on 8 July 2015 in the present case, enclosing the expert opinion of the FMT department, VSS Medical College, Burla, which again categorically states that, open quotation, drug NAC is not responsible for the death of the deceased, unquote. This court had on 24th April 2012 directed that the further proceedings in GR case number 508 of 2003 shall remain stayed. That interim order is continued. Paragraph. The evidence does not support the case of the prosecution at all, and the remark of the CJM to the contrary appears to be erroneous. Stop. Continuing the prosecution against the petitioner, the circumstances appears not to be justified at all. We'll stop for the aforementioned reasons. GR case number 508 of 2003, pending before the learned CJM shall stand quashed. The petitioner shall stand discharged in the said case. The impugned order of the CJM is hereby set aside. Obliged. The petition is disposed of in the above terms. A copy of this order be sent to the concerned CJM forthwith.
Obliged. Specialist item 31. Item number 31.
None appears to dismiss from opposition.
Specialist item 32. May I please, your lordship? My lord, the petitioner and a opposite party number 2, they both are in law. They both fled away. Mother of the opposite party number 2 lost the affair, and basing upon that affair, the case was registered, and the petitioner was arrested. Victim was rescued. Her 164 statement was recorded. That is at annexure 2. That is in ODI, running page 13, starting from running page 13. She stated that she is in love and married to the petitioner. She wanted to stay with the petitioner, but since by that time the victim was minor, he was given custody of the short stay home. Thereafter, after getting the majority, she released from there, and the petitioner also released. They already married, my lord, and blessed with children. Now the petitioner challenging the order of cognizance, that is annexure.
All right, you say the court has perused.
My lord, I am appearing for the opposite party number 2.
Yes.
My lord, I have been married to the petitioner from last 10 years, and from then only I'm residing a conjugal life with him.
Right. All right. An affidavit has been filed by opposite party number 2, stating inter alia that she has been married to the petitioner. For over 10 years now, and that she has no objection if the order dated 12/12/2011 passed by the JMFC Chandigarh in GR case number 660 of 2011, arising out of Bali Chandrapur PS case number 114 of 2011 against the petitioner is quashed. It is noted that the couple have 2 children in the meanwhile. Full stop. This court has also perused the order already passed by this court on 17 May 2012 in the present matter, noting that the in-laws of opposite party number 2 gave an assurance that they would take good care of opposite party number 2. Paragraph. In view of all of the above developments, the court quashes the order dated 12/12/2011 passed by the JMC Chandigarh, taking cognizance against the petitioner in GR case number 660 of 2011, arising out of Bali Chandrapur PS case number 114 of 2011. The petition is allowed no order system. Copy of this order be sent to the JMFC forthwith. All right.
Specialist item 33.
None appears. Dismissal on last question.
Specialist item
order is
34.
Mr. Bose was here.
Item number 34.
None appears. Dismissal on last question. The interim order is vacated.
Specialist item number 35.
My lord, in this case, the counsel for the petitioner has died, and one of his associates is also died. My lord, I have, since I am holding the office of Mr.
We'll leave it open to the petitioner to say urge all the, please, this is item 35, right?
My lord.
1 minute, let's see what the matter is.
My lord, may I pray, my lord? My lord, some adjournment, my lord, one adjournment may kindly be granted, so that I'll send the intimation, my lord. My lord,
1 minute. This is Food Adulteration Act.
Yes, my lord. My lord, one adjournment, my lord.
No, no, what is the matter? Have you actually bothered to find out what the case is about?
Okay, my lord.
Ah,
Lord, this is arising out of a 2cc case, my lord. Of arising out of a Food Adulteration Act.
Page 28, Annexure 3, my lord.
yes,
Now, that is a sanction order.
yes,
Subparagraph 3 on observation.
yes.
On observation of the above documents along with the reports, I have been satisfied that the sample of the above two samples were taken for chemical examination on payment of rupees so and so. The sample of just protein syrup has found to be adulterated by report number so and so Orissa. Prima facie case has been instituted against the above responsible persons for the offence of storing, supplying, and selling of adulterated food article for human consumption. So let him face the trial and he can raise all these questions during
Correct.
trial.
My lord, he is the director, my lord. My lord, he is the director. My lord, director of the company. I am the petitioner is the director of the company. My lord, the accusation is not directly against the present director.
Where is the complaint? Copy of the complaint.
Complainant as
Prosecution report. It's against Amit Kumar Chaudhary.
Yes, my lord. I am not.
And the second simply says director.
Simply says the director, my lord. My lord, that is why, my lord, that is there is a lengthy hearing is required, my lord. My lord, in the writ petition also there are so many citations have been relied, my lord. I have not been prepared thoroughly, my lord.
Are we supposed to keep adjourning because you are not prepared thoroughly? You can pass it over, you get prepared thoroughly.
My lord,
we'll pass it over. I'll pass it over, we'll help you argue the case. All right. Pass over.
Specialist item 36.
May I please, your lordship? My lord, 138 challenge here. Basically, at the ground, my lord, the notice was not sufficient. And so also, my lord, the complaint was premature. In either case, possibly this is a question of trial.
Yeah. Leaving it open to the petitioner to urge all the petition points raised in the present petition at the appropriate stage before the trial court. The petition is disposed of, the interim order is vacated.
Specialist item 37.
None appears dismissed in non-prosecution. Interim order is vacated.
Specialist item 38.
We are for the opposite party, so kindly delete our name. My consent has taken. 38.
Counsel petitioner seeks leave to withdraw this petition. Dismisses withdrawn. The interim order is vacated.
Specialist item 39.
None appears dismissed in prosecution. The interim order is vacated.
Specialist item number 40.
None appears dismissed in non-prosecution. Interim order is vacated.
Specialist item 41.
I don't know. I am in BC, my lord. I am for the petitioner. My lord, case is, my lord, they both relates between husband and wife, my lord. In this case, I have challenged under Annexure 3 for passing up a cognizance, my lord. In this case, what happened? Initially, case was registered under section 498A, 294, 323, 313, 506, 34 IPs, my lord. And after investigation, the IO has submitted charge sheet under section 498, 506, 323, except my lord 313 has not been there. And the court has taken cognizance without verifying the documents on record.
It's all right, sir. All these pleas you can take at the appropriate stage. So permitting the petitioner to urge all the pleas at the appropriate stage.
And so
the petition is disposed of. The interim order is vacated. Yes.
Just I am placing my lord. 313 is not attractive. And so far,
it's all right, sir. All this you can point out to the trial court at the appropriate stage. Yes.
Specialist item 42.
May I please, your lordship? Offense under section 294, 447, 323, 354, 379, 506 by 34 of the IPC. The informant and the petitioner are neighbor, and as per the prosecution allegation, occurrence took place on 15/5/2011.
3 months thereafter, they filed a 1cc case, which was registered by the concerned PS under section 136(3) of the CRPC. And offences travelled by magistrate as on today, the petitioner one, a 64-year-old, and 2 3 are ladies.
So all right, so you
As
can
per the
point it
court-
all out to the trial court at the
After
appropriate
3 months of the occurrence, my lord,
It's all right.
Law-
We
law
say
the complaint
permitting the petitioner to raise all the pleas urged in the present petition before the trial court at the appropriate stage, the petition is disposed of, interim order is vacated. All right.
Specialist item 43.
Worship, in this case, kindly permitted to hesitate all the power.
Yes, yes, same order in this. All right,
Not in.
all right.
Specialist item 44.
44, your lordship, this petitioner before your lordship is an old lady of 62 years.
62 is not old, sir. Please don't tell me that.
Sorry. And challenge the order of cognizance on the section
Yes.
that is available to your lordship and annexure 2.
So we'll permit you to raise all the pleas. You say,
Whereas the
permit-
NBW was issued.
that's all right. You appear on a particular day, the NBWD will get vacated. When will you appear?
Actually, within 2 weeks.
All right. The permitting the petitioner to raise all pleas urged in the present petition at the appropriate stage in the trial court. The court declines to interfere in the present petition and disposes it off. As far as the NBW is concerned, counsel the petitioner states that the petitioner will appear before the trial court on 4th July 2022. If the above assurances are there too, then the bail application of the petitioner will be taken up soon thereafter, and an appropriate order will be passed by the trial court. All right. The petition is disposed of.
Specialist item 45.
May it please your lords, my lord. Here, my lord, I have challenged the order passed by the land magistrate on 5/8/2012. My lord, may kindly see.
Yes.
My lord, cognizance has been taken under 18 of PNDT Act. PNDT, my lord, is Preconception and Prenatal Diagnostic Technique Prohibition of Sex Selection Act at 19.
Right, right.
My lord, this case, my lord, my case is covered under the reported case of this court, 2018, volume 70, OCR, page 397. Same complainant, because I have, let me draw my lord's attention to the notification, my lord, basing upon which, my lord, may kindly see page 12.
Yes.
Page 12 is a gazette notification of Government of Orissa, wherein, my lord, may kindly see office memorandum. In pursuance of the office memorandum number so and so, dated 12th February 2007, the Ministry of Health and Family Welfare, Government of India, the district magistrate has been declared as district appropriate authority under section 17(2) of Preconception and Prenatal Diagnostic Techniques Act 1994, amended in 2002. Accordingly, the state government is hereby appoint the appropriate authority. So the appropriate authorities are district appropriate authorities, district magistrate of each district is hereby appointed as district appropriate authority. He may nominate an executive magistrate. Sub-district appropriate authority, while the subdivisional magistrate, sub-collector of each subdivision is hereby appointed as appropriate authority for the sub-district. So CDMO is not the appropriate authority to initiate the case. My lord, must be hour of the off-quoted decision, AR 55, Supreme Court 196. The things which has been directed to do in a particular manner, that is to be done in that way, otherwise it should not be done.
All right. Where's the decision of this court?
Well, the decision is 2018, volume 70, OCR 397. The same day, the same CDMO has filed a complaint, my lord, and committed seizure with regards to Dr. Prabhat Kumar Jain of the same area. And that case has been taken note of by this honorable court and has been quashed.
Yes, Mr. All right. Yes, Mr. Mudli.
Same Dr. Acharya, CDMO, Narayan Acharya was the CDMO. And the court said he has not been authorized by the statute to do so. Paragraph 9 and 13.
This one.
First.
Yes, Mr. Mudli.
Kindly. This annexure KY1.
some matters, before ballot may pass any order, I want to draw my lord's kind attention to a fact, ballot, which I should, as a lawyer, I should point out, because the similar matters have been extensively heard by Honorable Justice A.K. Patnaik, and our judgment has been reserved. So, my lord, out of the 10
Justice R.K. Patnaik.
Mr. R.K.
This is Justice R.K. Patnaik.
Justice R.K. Sorry.
Ah.
I was a bit.
So shall we place this before the same bench?
I think, my lord, because to maintain.
All right. The court is informed that similar matters have been already heard
and
orders reserved by the bench of Honorable Justice R.K. Patnaik. Place this petition also before the same bench.
Because out of the Lord Pilot, two petitioners are there, though where Dr. Acharya is the complainant.
Right. On 8th July,
Pilot.
interim order to continue.
I thought, ballot, I should, because there will be multiplicity of judgment ballot on this.
Correct.
Specialist item 46.
That appears dismissal non-prosecution. The interim order is vacated.
Specialist item 47.
May I praise your lordship? Yeah, my lord, the petitioner has challenged the proceeding.
(164) statement is there. Okay, she has given an affidavit saying she is not willing to proceed with the matter. Opposite party number 2.
The case number 376.
Oh, it's a
Case number
376.
Yes.
Oh.
Now she has filed an affidavit saying that it has been compromised between the parties. As per the case diary, my lord, there has been pressure on the part of the informant's family to settle the matter. For which
Even that 164, just see that. Have you seen the 164?
Is it?
It's in Orissa. You tell me what it is.
It is at FAG 6.
Yeah. Can you read? Tell me on the screen it is there. So it's compromised again. That's what she says.
But not compromised, but
doesn't want to proceed with the case.
She may direct them to appear before the trial court and record the submission.
Correct. That's the best thing, sir. The report of the JMFC has sent to this court copy of the statement made under 164 CRPC by the informant. The court has also perused the affidavit filed by the informant before this court on 7th August 2012. In both these statements, she claims that she had filed the complaint against the petitioner by mistake, and that she is not willing to proceed with the case any further, and that the matter has been single court settled between the parties, unquote. Both parties will appear before the concerned JMFC's court and get their respective statements recorded, after which the JMFC will proceed in accordance with law. The petition is accordingly disposed of. The matter will now be listed before the JMFC. Chandikol, right?
This JMFC Chandikol, yes.
Chandikol. The case, namely GR case number 749 of 2011, will be taken up by the JMFC Chandikol on 11th July 2022, on which date both parties will appear.
As per law, my lord, because there are decisions which cannot be compounded. It's a non-compoundable offense.
So discharge.
What should we say? As per law, let it be.
That's what I've said, as per law.
Yes,
Specialist item 48.
Now, this is a matrimonial dispute, my lord.
Ha.
Here, my lord, there was a decree of divorce between the parties, mutual decree of divorce.
Okay.
Between the parties, your lordship.
So this you
She
can
has already taken the permanent alimony. And the wife has filed the petition for divorce, my lord, which was allowed.
All right. But this is 498A, right?
Yes, 498A. But
Already
no document has been given to indicate the, my lord, the
I
question
have
of,
given, my lord, the lordship can state the judgment.
it has not been annexed.
Subsequently, it has come, my lord, in 2016. The order was passed.
Yes,
Wife has filed for divorce. She has taken the permanent alimony. And 406, my lord, will not be made out in the judgment that is reflected that she has already taken away the articles.
Why don't you give him a copy?
Yes, let her
Yes.
give a copy because other accused persons are also there. Apart from
Yes.
husband, in-laws are also there.
So, but once a divorce is granted,
Husband against
No, because that is not on record. That's what I'm asking.
give him a copy.
My lord. Your
No, no,
lordship.
why not? I'll just pass it over. You can give him a copy. Just
I
make a
also give
photocopy.
copy to your lordship, my lord.
No, no, and also to him. I'll record it in the order. We just pass it over, you make a copy and give it to him.
Immediately, my lord, take time.
What will take time? Nothing.
Xerox, my lord.
All right, you at least show it to him.
I'll go through. Pass it over, madam.
I'll just pass it over. All right. You pass it over.
I am a single person. Where I will go, I will.
You don't have clerks. I'm sure you have a whole office. Yes.
There is a Passover, my lord.
Passover.
Item number 28, my lord, that has been
Ah.
passed over. Kindly taken up, my lord. I will do that.
Yes, yes, we'll take it up together. When this is called up, that will also be called up.
Specialist item number 49.
May I please, your lordship?
Yes.
Your lordship, challenging the order of cognizance in a 138 NI case. Your lordship, my ground is that the complaint petition has been preferred after the expiration of the said period, your lordship, which is 2 months after the expiration of the said period. And your lordship, the condemnation of delay, the complainant has preferred a condemnation of delay petition, which has been allowed on the grounds that the postal endorsement has not been received. And your lordship, no opportunity has been given to us to object the petition. And your lordship, the complaint petition has been preferred under section 138 NI along with section 420 IPC, your lordship, which are both mutually exclusive. This is a separate criminal case and 138 is relating to the check bounce offences, your lordship.
Who's for the other side? Must be a private complainant. Have they been served? Has the opposite party been served?
Mr. N.K. Ratho is appearing, madam.
Sorry?
Mr. N.K. Ratho is appearing. His name is in.
Oh. We'll just pass it over once. We'll pass it over once.
My lords.
Specialist item 50.
None appears.
Specialist item 51.
50 is this for non-possible.
51.
Interim order separated of that.
There is a mutual consent of divorce, my lord, at that annex page 11, annex 2 series. Decree of divorce was passed. Thereafter, my lord, a FIR has been lodged. Annex 2 series, your lordship kindly see, page 11.
Yes.
I have challenged the cognizance order dated 12/8/2010
2010.
at
Right.
page 26. On that ground, I have filed this case for quashing.
All right.
But here, FIR has been lodged in 2009.
That's right.
Cognizance of the year 2010 and mutual divorce in 2011.
Correct.
But she has been made a party. It's better if it takes notice to that.
My notice is done, my lord. Nobody appears.
All right. None appears for opposite party number 2 dispatch service. The petitioner has placed on record copy of the judgment dated 20th April 2011, by which divorce by way of mutual consent under section 13 capital B of the Hindu Marriage Act 1955 has been granted by the Judge Family Court Khurda in civil petition number 167 of 2010 paragraph. In that view of the matter, the petition is allowed. The order dated 12/8/2010 passed by the SDJM Khurda, taking cognizance in GR case number 656 of 2009 is hereby set aside.
Specialist item 52.
May I please, your lordship? Lordship, challenging the order of cognizance
passed by the STGM Banki Kotak in GR case number 67 by 2011 for offense under the 351, 448, 353, 427 and 506 of IPC. That the allegation in the FIR honor annexer 1, page 6, that the present petition by manipulating the records of +3 art stream in the name and style of Orissa College appointed some antisocial personnel and have only.
Sir, all these pleas can be taken at the appropriate stage.
Yes, page 12, my lord, he is an absconder. Charge sheet has been filed and NBW is pending. Let him surrender and then.
The fact is, Lordship, the present petitioner is the president
Page
of
12.
the +3 arts college. That is the also.
Sir, you have to appear before the court, sir. You are absconding.
Yes, let him surrender.
Yes, yes.
Let's
Permitting the
say I-
petitioner
I-
to urge all the pleas raised in the present petition at the appropriate stage of the trial court, the petition is disposed of, the interim order is vacated. Right.
Specialist item 53.
None appears, dismissed for non-prosecution. The interim order is vacated.
Specialist item 54.
Same.
Specialist item 55.
None appears, dismissed for non-prosecution. The interim order is vacated.
Specialist item 56.
None appears, dismissed for non-prosecution. The interim order is vacated.
Specialist item 57.
Item 57, my lord. Here, my lord. My instruction is an affidavit has been filed for compromise before the learned trial court, my lord.
So that's okay, then you can proceed there, sir. Counsel to the petitioner informs the court that the compromise petition has been filed with an affidavit before the trial court, permitting the petitioner to proceed with the said application in accordance with law. The petition is disposed of, the interim order is vacated.
Specialist item 58.
My lord, in item 58, kindly order dated 6/12/2012, the order for conciliation by sitting together was passed. Kindly, if my lord gives me 1 week time till next Friday, I will find whatever it is, because we could not contact the petitioner yesterday. Otherwise,
It's all right, sir. We just permit you to erase all the pleas.
praying
And if
for
you
quashing of
compromise, you
effort.
inform the court.
Yes.
Permitting the petitioner to raise all the pleas urged in the present petition at the appropriate stage before the trial court, the petition is disposed of. If the petitioners, if a compromise has been reached, that will also be brought to the notice of the trial court. The petition is disposed of, the interim order is vacated.
Specialist item 59.
Pardon, my lord. My lord, in item 57, my lord, opposite party present, my lord.
All right, just make a note of that.
Item 59.
All right, none appears, dismissed for non-prosecution, the interim order is vacated.
Specialist item 60.
Sorry?
Monday night.
But kindly taken on Monday.
No.
His relative is expired last night, man.
What is it, sir? Just see what it is. Judgment dated 7/8/2012.
Page 32. The proceeding under section 133. It's a conditional order, my lord. Relevant portion is page 37, my lord. Para 11.
Why should one interfere with all this, sir? Just read para 11. As it is, it was more than 10 years ago. This is the complainant's revision.
More power, man. I have no power.
Kuladevi. Chaitan Dehuri. This must be Chaitan Dehuri's.
This case, I am for the opposite party number 2 to 5. The petitioners, they have approved the Human Rights Commissioner and on the recommendation of the Human Rights Commission, the SDM Angul has initiated a proceeding under section 133 CRPC against the opposite party number 2 to 5 regarding establishment of the stone crusher. Stone crusher has closed since
10 years. Then
you have to currently page 35
correct. I saw that. Long 10 years ago, it had been stopped.
It was established following the due procedure.
Correct.
But subsequently, that has been stopped functioning and closed.
Right.
So that is why the Lord and Session Judge Orgul has.
Correct. A copy of the present petition challenges an order dated, judgment dated 7th August 2012, passed by the learned District and Session Judge Angul in Communal Division number 3 of 2007, which in turn arose out of an order dated 30th November 2006, passed by the Subdivisional Magistrate Angul in CP3, case number 501 of 2002. Paragraph. The villagers of village Malisahi and Panchamahala had filed a complaint on 30th October 2002 before the National Human Rights Commission at New Delhi, NHRC, as a result of which the Additional District Magistrate ADM Anugul initiated the case under section 133 CRPC, that is CP3, case number 501 of 2002, against the opposite parties 2 to 5 on the ground that they were unauthorizedly operating a stone crusher in the name and style of Messrs. Balaji Industries, which is severely polluting the environment and causing health hazard. Paragraph. An order was passed by the SDM on 30th November 2006, directing opposite parties 2 to 5 to stop operating the crusher unit within 2 months. Paragraph. In the impugned judgment dated 7th August 2012, it is noted by the learned Sessions Judge Anugul as under. Reproduce over of para 11 at page 37. Paragraph. The court sees no reason why it should interfere with the above conclusion in the impugned judgment, particularly since the crusher unit admittedly stopped functioning since 1st November 2002, that is nearly 20 years ago. Stop. Keeping the present proceedings alive would serve no purpose whatsoever. The petition is accordingly dismissed. The interim orders are vacated.
Specialist item 61.
I have challenged Annex 4 order dated 25/6/2012, my lord. Here in this case, immediately petition number 1 lodged an FIR against the present opposite party. When he was taken into custody, after release, my lord, he filed a complaint case alleging all the things, and cognizance was taken after so many days.
It's all right. Leaving it open to the petitioner to urge all the pleas raised in the present petition at the appropriate stage before trial court. The petition is disposed of. The interim order is vacated. Yes.
Specialist item 62.
May I please? In this case, your lordship, the petitioner challenged the cognizance order of the learned SDM read up to your lordship. Cognizance will taken.
By apology, lordship. The cognizance has been taken under section 420-294-506, your lordships. And going through the initially, your lordships, when the complaint was registered, that was sent for the investigation under 156/3, your lordships, and the police filed the final report stating that the case is false. Thereafter, the petitioner files the
complaint. Correct.
Complaint, yeah? And the under 202, 3 witnesses were examined, your lordships. They are also not supporting the case is, your lordship, that the present petitioner and the opposite party number 2 were residing as husband and wife, and the present petitioner took a loan of 1,50,000 and did not repay the loan.
Yes.
As per the statement of the witnesses also, your lordships, that this has been given a color of the 420 cheating, your lordships, but the basic ingredients, the malified intentions or the mens rea is absent, your lordships. As per the statements recorded of, as per the deposition of the witnesses also, it is clearly revealed that even if assuming the allegations to be true, your lordships, it only leads to a civil suit, your lordship, money suits, not to,
sorry,
even assuming the allegations to be true, your lordships, that only that this constitutes a civil suit, your lordship. The in basic ingredients are missing, your lordship, of 420 and criminal offense, your lordship. Here the lady has come up before your lordship. The allegation is that the lady and the other person, the complainant, they were staying as husband and wife. During the course of staying together, my lord, she had taken some money from the man and she was not returning it. And when he knew about the second marriage, I mean the marriage which is about to take place, he went and asked her about the money. She refused, and then thereafter he lost the complaint case.
How is this a criminal case, sir?
That's fine, but here the lady has been noticed. She has appeared. So it's better both of them may not appear before the trial court and record their finding. If it is a civil nature.
Harassment, sir. That's your harassment.
Because evidence has to be led, my lord, by the accused also, so as also the complainant. My humble continuation.
The petitioner wanted to restrict her from the. Where are the three statements you said which don't support make out the case?
Lordship. That is in annexure to page 15. 15 and 16 and 18. But they are the witnesses, my lord. They are the accused, not the complainant. The complainant had made them the complainant is Satyanarayan Sahu.
These are depositions in the trial.
Under 202 proceedings. Yes, ma'am.
After the police filed the final report, the magistrate took process under 202.
It is at the stage of lodging of complaint, 202 inquiry, my lord.
After the protest petition.
May I pay lordship and leave it to the trial court, let them record the submissions, and then
it would be
evidence has to be recorded.
It would be clear abuse of the process of the court.
Correct. Case of 2010.
Yeah, it seems a level harassment. Actually.
As it appears from our
once a closure report has been filed with the police,
yes,
to again go in a private complaint seems a bit much.
As it appears, my lord, no stay order is also there. So probably the stay.
No, there is a stay order.
In our record, my lord.
No, there is a stay order.
Stay order.
You see, the present petition challenges an order dated 22nd May 2012, passed by the SDJM Sambalpur. Sorry, passed by the SDJM Rairakhol, right? Rairakhol, lordship. In CT case number 165 2012.
11. Annexure 3, page 20.
It's a 2011,
my lords.
Because the order dated 5th July 2013 says it should be corrected as CT case number 165 2012.
Annexure 3 at page 20 says it's CT case number 165 of 2011.
11, right. It is all typed copy. That's the whole problem.
Yes.
Taking cognizance against the present accused under section 417/494 IPC, as well as section 294, 420 and 506 IPC. background of the present petition. You see, while directing notice to issue in the present petition on 7th November 2012, the further proceedings in the aforementioned case was stayed by this court. Stop, that stay has continued since. Despite service of notice, none appears for the opposite party number 2. Although appearance had been entered at one stage on his behalf. Paragraph. The background to the present petition is that the complainant and the present petitioner were residing together as husband and wife. The allegation was that she took 1.5 lakhs from him on the assurance that she would marry him. When the complainant came to know that the accused was going to marry some other person, he then filed an FIR filed a complaint petition, which was then referred under section 156(3) by the SDJM to the inspector in charge, Charmal PS, to register a case and in fact investigate the alleged offences. So, however, the police filed a final form on 3rd October 2011 describing the FIR to be false. Paragraph. Thereafter, the present complaint under section 200 CRPC was filed. No, thereafter, notice was issued on this to the complainant, who filed an objection, who filed a protest petition on 2nd November 2011. Full stop. That was allowed by the SDJM. And on 8th November 2011, and the matter was fixed on 8th November 2011 for initial statement. Full stop. On perusal of the said statements recorded under section 202 CRPC, the magistrate, the SDJM passed the impugned order taking cognizance, which has been challenged in the present petition. Paragraph. Copies of the statements recorded under section 202 CRPC have been enclosed to the present petition. They do not actually make out a case for any of the offences for which cognizance has been taken. So it appears to be a purely civil dispute and it's been given the color of a criminal case, which was nothing but sheer harassment of the petitioner. Full stop. Consequently, the case, the court sets aside the impugned order dated 22nd May 2012, passed by the SDJM Sabalpur in the aforementioned CT case number 165 of 2011, and the petition is accordingly allowed. No orders is to pass.
May I allow to correct you? The SDGM Redacol, your lordships.
Redacol,
Correct.
sorry, Redacol, correct.
Specialist item 63.
It is 165 2011,
Lordships.
because in the order that was passed by the High Court, the correction was carried out as 165 2012. That's why I'm asking.
It is 2011, your lordships.
All right. 2011. Right.
Item 63.
On behalf of Mr. S.R. Mahapatra, may I please your lordship? Your lordship, I am challenging the order dated 18/7/2012 passed by learned additional sessions judge Puri under sections 506, 34 under section 31X your lord of the SC/ST Act, your lordship. Your lordship, the informant is the superintendent of police CBCID who has lodged the FIR, your lordship, alleging that during course of an investigation of a previous case in favor of both the accused persons in the present case, that is Pipili PS case number 13 of 2008, your lordship, under sections 341, 350.
All these pleas can be raised at this stage, sir. We're not.
That's only 506 and 34 of IPC has been framed against the
That's
present
what, you can raise all these pleas at the appropriate stage. We say permitting the petitioner to raise all the pleas urged in the present petition at the appropriate stage of the trial court. The petition is disposed of, the interim order is vacated. All right.
Obliged, Lord.
Specialist item 64.
Before you not submit disposed of this thing that I will raise all the pleas.
Same order in 64.
Specialist item 65.
In 64, my name may be reflected.
All right. The opposite party.
65.
Respected sir, I am appearing on behalf of Mr. Chinmay Mohanty. And in this case, there are no instructions, such instructions from the petitioner.
All right. Counsel, the petitioner states he has no instructions. The petition is disposed of, interim order is vacated. Yes.
Item 66.
None appears, dismissed not prosecution. The interim order is vacated.
Item 67.
May I please allow?
Yes.
My lord, the order dated 27 July 2012 passed in GR case number 845 of 2011 by the learned JMFC Kujang, taking cognizance of the offence under section 420, 468, 469, 471, 294, 506 and 34 IPC and is on a challenge. Here, my lord, it is a clear case of civil dispute. The petitioners who are it is arising out of a complaint case and in exercise of power under section 156(3) of the CRPC, the matter was sent to the police and subsequently it was registered as FIR and
Sir, there must be some allegation of forgery of documents.
Yes.
No, I have not managed. We are the bona fide purchaser of the land.
Whatever, sir, the documents are forged, everybody gets in.
The sister of the complainant had
So
entered into an agreement with
there
these.
is no question of forging document, man. We have just purchased the land. We have
Page 12.
purchased the land from the sister of the informant, the complainant. Admittedly, she is the shareholder. And the charge sheet has been
That is the
submitted
problem,
on the
sir.
ground.
That is the problem. That is the problem.
Page
The
12
charge sheet has been submitted by the police on the ground that without verifying the document, we purchased the land.
KV Temptor. So you can urge all these pleas. You say permitting the petitioner to urge all the pleas raised in the present petition to the appropriate stage. The petition is disposed of. The interim order is vacated. Yes.
Item 68. May I please, your lordship. My lord, charge sheet was filed against opposite party number 2. And after verification of the signatures, your lordship would find the police finds that my signature doesn't appear in the alleged agreement. Accordingly, only the charge sheet was filed against the opposite party number 2. On the basis of a protest petition, now the cognizance has been taken. My lords may kindly turn to page 14.
So this can be raised at the appropriate stage.
Portion of the charge sheet. The charge sheet clearly it says that my signature is not there. Why I am taking your lordship to that? Page 14, my lord. And in fact, undertaking has also been given by the opposite party number 2 that he has collected the money and he will pay it off. The page 14, my lord, towards the middle, the accused issued loan agreement containing the signature of MD of 7 Hills such and such, a loanee, but did not deposit the money in 7 Hills estate. It is also confronted that the MD Srinivas disowned the signatures of the loan agreement and his own denied receipt of the money from Ashok Patnaik. The accused Ashok Patnaik has also given written undertaking who have received the money from the complainant and to return the same, but did not do so. The accused Ashok Patnaik has committed many such similar offences at Sunamada, Jaipur, Koraput, etc., cheated crores in the innocent people. Thereafter, my lord. Further, during investigation, the previous I have examined the complainant, seized the connected documents, some documents, other witnesses have been examined, and prima facie this case came out specimen signature and handwriting of MS Srinivas and the accused Ashok Patnaik have been collected and
So
sent to
general manager, he was your general manager, you are the managing director.
No, he was not. That he represented that way. The admitted handwriting of signature of that thereafter, my lord, may kindly bear with me. The admitted signature of the MS Srinivas and accused Ashok Patnaik have also been seized. The expert opinion with regards to the
Comparison of handwriting and signature of the accused Ashok Patnaik and MS Srinivas have been received. Analyzing the alternative effects of the prima facie evidence came out against accused Ashok Patnaik, and accordingly remand report was submitted to the IO such and such on 2/4 and the court of SDGM Berhampur to remand the accused of Ashok Patnaik in this case. Accordingly, charge sheet was filed only against Ashok Patnaik under section 420, 468, 471. Thereafter, this protest petition came and cognizance has been taken. That is what I am questioning.
So amount involved is 17 lakhs.
17 lakhs.
How much has been given back?
I have not taken any money, my lord.
That is the whole problem, sir. Then they never get settled. This whole problem is all in denial. Somebody has lost 17 lakhs. He's got not a penny back.
But then again, my lord, this could at least be a civil dispute.
Civil dispute.
Somebody alleges my signature is not there.
Hundreds of people of that locality. It's a
Correct,
Ponzi
correct.
scam. This cheat fund.
Correct,
Hundreds
correct.
of people is the managing
This is not part
director.
of the cheat
He
fund.
is the marketing agent.
Permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage before the trial court. The petition is disposed of. The interim order is vacated. Yes.
Specialist item 69.
69. On behalf of Mr. Mahapatra, your lordship, no instruction.
Okay. No instructions disposed of. The interim order is vacated.
Item 70.
None appears dismissed for non-prosecution. Interim order is vacated.
Item 71.
71 permitted to withdraw, my lord, because I have challenged the order FR, my lord.
Or counsel, the petitioner seeks leave to withdraw this petition. Dismiss. This withdraw. Interim order is vacated.
Pastoral matter. Specialist pastoral matter, item number 11.
I be permitted to raise all the points before the
Permit to
trial.
raise all the pleas at the appropriate stage of the trial court. The petition is disposed.
Problem.
Interim order is vacated.
Specialist item number 28.
Mahapatra.
She
Saw
was,
that,
she was mentioning this matter.
Total matter is 70, my lord. I am wrongly 71.
He wrongly mentioned 71. 71
Oh.
is civil
70
division.
Yes, ma'am. My matter is
I am
70.
here, my lord. He has wrongly mentioned my matter.
I see. 71. Okay. Call out 71.
70 is withdrawn.
71.
70 withdrawn.
7 is withdrawn. Okay. 71. Yes,
Yes,
sir.
my lord, 71, my lord. My lord, that present petition was facing his trial, my lord. Being charged
Deposition
on-
copy, my lord, is not there. Copy of the deposition copy.
Copies are there?
But the evidence, but deposition of the witnesses.
We will
Who is
serve the
the-
deposition copy, my lordship. Take up this matter next week. We will serve the copy, my lord, on the state council.
So it's a
Alright.
case of 395.
Mr. Das states that he does not have copies of the depositions of the witnesses. Mr. Devasnan Das, learned counsel appearing the petitioner, undertakes to serve it 1 week prior to the next date.
Yes, ma'am.
22nd July, sir.
Yes, my lord. Always.
Pastoral matter, item 28.
28 is where the divorce has happened.
No, this is not.
That was 40.
Passing of proceeding. Probably she has gone to copy that statement. Let's not keep it to any other date.
Next Friday. Next Friday. List on 20.
Item 35.
This is a 2cc case. Number 34 of 2007, my lord. Offenses under section 7I, 5I, 2IA and C, punishable under section 16A, IA, and 17 of the Prevention of Food Adulteration Act 1940. My lord, there are 3 questions are involved in this.
This is where you are the director.
My lord, this is the present petitioner is
Isn't
not
there a-
director, my lord.
Sorry?
The present petitioner is the director, my lord.
Right.
In fact,
And he has not been named.
in fact, the petition is misconceived because you Lordship can see the prosecution report at page 29.
Which item number is this?
Page 29, annexure 4.
Ah, right. 29.
Annexure 4. Lordship can see cost title, opposite party number 2, the director, Mr. DWD Pharmaceutical.
That's right. It simply says the director.
No, address, my lord, can see Banka Bazaar. Now, the present petitioner, well, he happens to be from
Mumbai, my lord.
Correct.
Notice was issued to the office at Banka Bazaar because your lordship can see same page towards bottom your lordship can see. The notice was issued to the supplier, not to the manufacturer. Last but one paragraph your lordship can see. Then I taken 3 sealed packet of Aglobit chocolate flavored having 200 ml each and 3 sealed bottle of Zest protein syrup having 200 ml each and paid him ₹100 toward the cost of the above 2 articles for which he was given me a money receipt. Along with this, he has given me the Xerox copies of the bills of 2 farms of Kotak from where he has brought those 2 articles for selling in his shop. So notice was issued to the seller. He is the manufacturer now. He has approached minors.
No, he's approached because he's got notice. That's the whole problem.
No, you Lordship can see the summons. Summons at page 34, annexure 7. That is also Banka Bazaar.
But how is it served on him then? That's the whole problem.
So summons you Lordship can see.
No, if you say that he's not involved at all, then he's very happy. He'll withdraw this petition also. You only have to say that this is not meant for him.
It's addressed to Banka Bazaar.
So if you say that, then he can
clarify. He can clarify.
I have the appointment, my lord, on at paragraph 12, my lord. That on 17/4/2012, the process someone referred to herein before dated 2/4/2012 was received in the registered office of the company at Mumbai, directing the presence of the director of the company before the court of law and SDGM.
So this should be quashed then. The summons to him should be quashed.
Admittedly, as required under section 17, company has not been made as
Party. Correct. So without making, you say the present petition challenges the order dated 12/10/2007 passed by the learned SDGM Bolangir in 2CC number 34 of 2007, taking cognizance of the offence under section 16A(1)(1)(a) of the Provincial Food Registration Act vis-a-vis the present petitioner, who is a director of DWD Pharmaceuticals Private Limited. Paragraph. It is settled position law in Anita Hada versus, what is that? Anita Hada versus something.
NI Act is there. That is under the Negotiable Instruments Act. Exact reference.
That without impleading the company itself as a party, only a director of the company cannot be proceeded against. Moreover, the copy of the prosecution report indicates that the person sought to be proceeded against was the seller of the objectionable article, along with a director whose address was given in Cuttack. Full stop. It is a mystery how the summons ultimately came to be served on the petitioner, who is obviously a resident of Bombay. So in any event, criminal case against him cannot proceed unless the company itself is made a party. For all of the aforementioned reasons, vis-a-vis the present petitioner, the impugned order dated 12/10/2007 is hereby quashed. The petition is allowed. No order is to pass.
Let's not confine to so far the petitioner is concerned.
Yeah, I said only vis-a-vis the petition.
Item 48. It is that case which Ms. Mahapatra was mentioning.
Correct.
She showed us a copy of the judgment. So the marriage has been annulled. It is not correct. So
all right. What's the date of the marriage and that?
That she has taken back. She has taken back that. Your Lordship, we keep it to next Friday, another case.
Yeah,
also.
next Friday, both the matters, next Friday.
Item 49.
49, may I please, Your Lordship? Your Lordship, the opposite party was about to appear. That's why Your Lordship has passed over this item.
We'll take it up next Friday.
My lords.
All right, next Friday.
Good afternoon. May I please alert?
Yes.
Item 1. This application is filed reviewing the order dated 6/8/2019, where the application has been disposed of, the writ application disposed of without the prayer made in the writ application matter. Your Lordship shall look to the prayer of the writ application. That was.
Mr. Mahapatra, there is a delay.
Yes, my lord, I have filed a delay application and also a file and dispensing application. I have also filed a limitation petition, my lord, under section 15 application. My lord, the delay is that though the order was passed on 6/8/2019, but that was conducted by earlier Mr. Rajat Kumar Rathman, senior counsel, my lord, which was not communicated to the party. And subsequently, after March 2020, the coronavirus came and the administration as well the judiciary was stalled. In the meantime, Justice Mr.
No, sorry sir, coronavirus was in March.
March 21.
21. This order is 6/8/2019.
March 20, my lord.
20. All right, March 20. All right.
Yes,
All right.
yes, March 20. My lord, my lord, my respectful submission, the earlier counsel, Mr. Ratha, the senior counsel, has not intimated regarding disposal matter. Accordingly, the petitioner could not know about the position. And thereafter, Mr. Ratha has expired during Corona. Subsequently, avoid in my petition, then 8/2/2022.
How many days delay? That's also not clear. How many days delay?
My lord, the delay of
well over 400 days, sir.
Yes,
300 or 400 days.
Yes, yes, my lord.
Filing all happened during Corona time, sir. Filing never went down.
The petitioner came to know.
970 days.
Yes.
970 days.
Yes, my lord.
You say there's an inordinate delay of 970 days in filing the review petition. Even accounting for the COVID-19 period, the delay is still inordinate and not satisfactorily explained. Consequently, the court is not persuaded to condone the delay in filing the review petition. Consequently, the review petition is dismissed. Yes.
For admission, item 2.
Please, my lords, I appeal. So kindly turn to page, not ours.
This is after notice, Justice Mahapatra.
Yes.
Lordship, I am appearing in item number 2.
Lordship, this is the.
I am not engaged, Mr. Nafar, senior advocate, Mr. Nafar. Sorry.
He's probably in some other matter.
He is not in this matter, I think too.
Mr. Nafde, I think you're in some other matter.
Yes, my lord. My mistake.
Yes. All right. Yes, Mr. Dwivedi.
Yes.
All right. Yes.
Lordship, review. I have filed a review petition. Lordship, the impugned order is at page.
No, notice is already gone in the review.
Yes, Lord. The same bench. Lordship, the same bench. The order is at page 17, Lordship. Second para of the order, Lordship. Here the last line. The railways is not concerned with any of the orders. That is what I am in a fix with, Lordship. Now, Lordship, how this is error apparent on record. Lordship, this order refers to 3268 of 2019.
Right.
The contents of 3268 of 2019 shall be made applicable. Now, Lordship, at page 14, page 13, Lordship.
Yes.
it is the contents that the finding of WPC number 11830 of 2013 has been made applicable to the present order of the in the impugned order, Lordship. Now, Lordship, in 11830, Lordship, at page 21, 21, Lordship, of the written note. This is a judgment of this honorable court. Here, two enhancements of royalty were declared illegal. And Lordship, this was the relevant, this is the guiding portion of the order, which was to be followed in my order also. Here, Lordship, sees para 2, Lordship, which is very important. The petitioner shall approach their employers who are to compute the extent of which royalty has been deducted from their respective bills, and also to certify whether the enhanced royalties deducted from the petitioner's bills have been reimbursed or added to the contract price or not. In the event the employer gives the necessary certificate indicating that the enhanced royalty deducted has not been reimbursed, such certificate shall be issued to the petitioners within a period of 3 months from today. Page 21. Now, Lordship, my employer is railways. If that part, the railway is no way bothered about, is not concerned of the orders, it affects me, Lordship. So I have no prayer. I am not challenging the order per se. I am saying that report, this paragraph 20.
Only that line that the railways are not concerned should be removed.
That is not in consonance with the earlier order.
Yes,
The earlier order reveals that his employer.
This is Mahapatra, they only want that line to be removed.
Yes.
And the why this line was incorporated, because railway had a different contract with them, and that contract was awarded much subsequently. And so far as the royalty concern is concerned, it is this arrangement between the petitioner and the state government.
No, but you are the employer. Vis-a-vis him, you are the employer.
He wants to issue the certificate.
Certificate is being issued by you.
Your Lordship may simply observe that since it has been passed on the premises that in fact the railway has no nexus.
No. Let us, because unless create confusion.
That is what I am saying.
The scope of the review petition is only for a small clarification that the sentence in the second paragraph of the order dated 26 March 2019 to the effect, open quotation, the railways is not concerned with any of the orders, unquote, should be deleted, since that would create confusion in applying the order dated 18th October 2015 in WP civil number 11830 of 2013.
Yes.
Which was to ipso facto apply to the petitioner's case by virtue of the order dated 19/2/2019 in petition civil 3268 of 2019. Paragraph. In that view of the matter, the aforementioned line in the order dated 26 March 2019, namely open quotation, the railways is not concerned with any of the orders, unquote, is deleted.
And under the petition is disposed of. My representation I have to make within 4 weeks.
So at the time, accordingly, the time for the petitioner to make a representation is extended by 8 weeks from today.
Much obliged.
Yes. Sir.
All right. Thank you.
Sir,
Pranam, sir.
Press admission item number 1.
So
Yes,
kindly
Mr.
turn to-
Yes.
So kindly turn to page 85.
Yes.
The principal ground, if your lordship recollects, on the previous occasion,
Yes.
that a change in the tax structure does not warrant any change in the agreed rates. That's the basic proposition. And if your lordships turn to page 85, clause 3.
1 minute, Justice Rautri, you wanted to study the matter.
Sir, Mr. Nafade, your main contention is that this notification has no applicability to the present contract.
Correct.
Because that rates you had provided prior to commencement of GST regime has become approved upon execution of the contract.
Correct.
Yes, that is your main contention.
Yes.
So kindly come to your prayer.
My lords. Repetition. Your lordship wants me to see the prayer in the original writ petition.
Yes, in the original writ petition, your first prayer is to pass the notification dated 10th December 2018.
Yes, ma'am.
That means you have challenged the notification for quashing the same.
Because that cannot be the basis of changing the rates which are agreed.
That you have not said that it is not applicable to your contract. You have said for quashing it.
Correct.
Yes. So now your contract is executed in 2013. Sorry, 2014.
15th of January 2014.
And it was completed in March 2020. And in the meantime, the GST regime came from 1st July 2017.
My lords.
So under the GST Act, the contract, works contract is subject to GST assessment.
Correct.
For the balance work that has been done after 1st July 2017.
Correct.
So your case is not that your contract is not covered by GST Act.
That's not my case.
That is not your case. So by operation of GST from 1/7/2017, the balance work that you have not completed, that automatically comes under the GST Act for its assessment.
I am not disputing. GST applies. There is no difficulty.
Kindly listen to me. Then, when the GST is undisputedly applicable for the balance work, then the notification dated 10th December is also applicable.
No, sir. That's the point.
How?
That's the point. That's the crux of the matter, which we also missed and your lordships also missed. Now, let me demonstrate to your lordship why it does not apply.
And so before that, kindly listen to me. Now you come to the notification, the first clause 3, the first subclause of clause 3, that has been quoted in the judgment.
Yes.
You see at the judgment at page.
Your lordship will get it at 244. The relevant clause, your lordship will get it at page 244.
Yes. Come to para 17 of the judgment. There that clause 3 has been quoted. That it states, in case of work where the tender was invited before 1/7/2017,
yes,
on the basis of SOR 2014, but the payments made for balance work or full work after implementation of GST, the following procedures shall be followed to determine such and such. That means it directly speaks that it will be applicable for those contracts which were executed prior to 2017, but balance work remained there and completed after 1/7/2017. So how could you say that this is not applicable?
Now that's my answer. Kindly see, my lord, this notification has no statutory backup.
Yes.
It's an administrative order. That's my point number 1. So any action to my prejudice first must be backed by statute, where there is none. That's point number 1. Second, the rates are approved under the contract. So therefore, I have a vested right to receive the rates as per the contract. And that's the proposition which I am trying to place across for your lordship.
As per the judgment of our judgment, the works contract executed by you is subject to GST assessment, and it is a being and works contract, the GST provisions.
No difficulty, no difficulty. The tax law applies by its own force. I'm not disputing that. The question is whether the rates undergo, contractual rates undergo a change. That's the point which I want to,
because the rates that has been revised is in pursuance, is ineffective of that notification 10 December 2018. Because
so
that notification directly refers to that revised rates.
So that's the point in dispute.
Yes.
That this administrative order of 10th of December 2018 is not a statutory order.
Yes.
It's an administrative order. Now, therefore, by an administrative order, your lordships cannot change by contractual rates. That is the point. So kindly have a look at the contract. Kindly turn to page 85. Let me show to your lordship what are the...
No, your case is that in absence of any condition in the contract.
Correct. And in the absence of a statute.
Which has been...
And sir, in the absence of a statute, both.
Yes.
Now, there is no statutory provision which empowers the authorities to change the approved rates. There is no provision either in GST or any other law.
But by operation...
No. Actually, Mr. Nafre, should I come in now? See, there's a background to this 10/12/2018. How it happened was a large number of petitions had been filed, and that's referred to in para 24 of the judgment.
I am conscious of the fact all those petitions were dismissed. Some of the review petitions were also dismissed.
Correct, and persons are permitted to make representations.
But sir, kindly see, my point goes to the root of the matter.
But it's too late, sir. Actually, all these points should have been raised at much an earlier stage.
No, sir, they were not raised. With respect,
I know, that's right. It should have been raised. My point is that...
Sir, it should have been raised. That I am not disputing for a moment.
Yes.
But this is an error apparent on the face of the record because it goes to the root of the matter. So it goes to the very absence of the authority to change the rates. That's my point, sir. So kindly have a look at the contract for a minute, and then if there is any statute which empowers them to issue such an order, I am out of the court. So kindly see the contract.
Listen, Mr. Nafade, that you see the GST is applicable to all works contract.
There's no difficulty. I am not disputing.
Your case is that in your particular contract, this revised SOR that has been made pursuant to that notification will not be applicable.
So I am saying that this notification, so-called notification of 10th of December 2018 is not a statutory instrument.
No, that it is not. No, there's no issue on that it's not statutory.
So then the question is that how do we change the contractual agreed rates?
Then how the GST will be applicable for the balance work? Because once the rate of items you had quoted, it includes that prevalent tax rate.
So that makes no difference. That makes no difference. How I calculate and how I tender, it is not...
Actually, Mr. Nafre, it might hurt you, but it apparently benefited a large number of other contractors. That's how those representations were made, and in response to the representation, this whole scheme was drawn up, the whole set of guidelines.
Whether the other contractors benefited or not is, as far as I am concerned, is not a relevant circumstance with respect.
Whether that revised rates will be reapplicable to your rates that you had quoted by virtue of operation of that.
May I urge another point?
Question of law that you are raising now.
I agree, my lord.
Raised at the time of...
I agree. I agree with your lordship that this question was not raised.
Be a ground for review of the judgment.
So that is because it amounts to an error apparent on the face of the record.
No, but it was not raised, Mr. Nafade. If it is not raised, there's no question of error apparent in the face.
That is what I want to show to your lordship. What I want to place before my lord's consideration is this, that the court proceeds on an assumption that this administrative order of 10th of December 2018 is a source of power.
No, that is that because that notification for quashing. That's why the court proceeded.
So therefore,
it's not that the court has so much proceeded on its own. Based on your prayer for quashing of that notification.
I agree, my lord, that this point was not specifically raised, or if I may say so, not even raised. But the point is that it's a question of jurisdiction of the authority to change.
I think you'll be able to raise this in an appeal.
If I can persuade you not.
No. I think we'll leave it at that, Mr. Nafre. I think you've made enough of a point for an appeal.
There is another point. May I show
Yes.
me? Now kindly turn to page 244. Page 244.
Yes.
So kindly see clause 3, which is the clause which was relied upon by the court. In case of work where the tender was invited before 1st of July 2017,
Yes.
on the basis of SOR of 2014. So I pause here for a moment. That the SOR of 2014 is dated 10th of November 2014, which your lordship will get at page 186.
And that was revised. The question, that was not never question. Only the revised SOR was the question.
Sir, no, sir, because the basis of 2018.
You say even that won't apply to you because your contract was January 2014.
That's what I want to show to your lordship.
All this, Mr. Nafde, we wish you had argued it in the first place.
I wish that, but the point is, sir, ultimately, the article 226 is meant for justice. And
No, all that is fine. Because we will be opening up a whole thing which, again, all the petitioners will come. This will become untenable for us.
No, but sir, the question is not what impact it will make on other petitions. The question is whether the considerations of justice.
No, because many petitioners, I think, have followed this judgment, they followed the guidelines, they have rearranged the role affairs and so has the state.
Sir, can I not be an odd man out? Can I not be an odd man out to seek justice in your...
That cannot be a ground for review, Mr. Nafade.
Anyway, I have...
All right.
I have done my best.
Yes. No grounds made out for review. The review petition is dismissed. Thank you, but it was a pleasure listening to you, sir.
Grateful.
Orders item number 2.
In this matter, the Lordship is supposed to call for a report regarding his release on furlough for a period within a year. I may pay Your Lordship and some trouble. We have not received the report as yet.
All right.
Mr. Katke had called for the report. We have not received it.
Your Lordship may see the orders passed by the High Power Committee dated 23/3. I am submitting 23/3/2022.
Yes.
And
Submitted, Mr. Ponda, I have not seen it.
My lord, I have sent my clerk with a copy.
No.
I have sent my clerk to court number 20.
Yes. Sorry, I got it.
We'll take it up next Friday.
Next Friday.
My lord, my side
Next Friday we'll take it up, sir.
Only one line. I was on payroll earlier till 16th of this month.
Okay.
By annexure to the bail application.
All right.
Now by these orders, it has been extended by another 45 days.
All right.
But the jailer is insisting that I should surrender tomorrow.
You have to show him these orders then.
I have already given those orders.
No, that's not the subject matter here anyway.
I have served orders.
No, but that is not the subject matter here. So.
Let that remain in the brief. Next Friday, Your Lordship.
Next Friday. All right. At the request of Ms. Patnaik, who states that she is awaiting a report on the furlough granted to the petitioner, list next Friday. All right.
Number 2 minutes. Call for a report in my case also the same report.
All right. A report equally be submitted in the other connected petitions. All right. For connected appeals.
No, not in all, my lord.
Not in all, because two here.
Two of them are on bail.
In criminal appeal 522.
649. Mine is 649.
Criminal appeal 649. All right. In respect of criminal appeal number 649 of 2019. All right. Next Friday.
Item number 3.
Instead of Friday, why not Thursday? Next Friday is the last one.
We'll have to sit specially for this. That's why. All right.
Item number 3.
The matter was transferred to me. NOC was obtained, but I could not file my power because first I was suffering from viral fever. Then immediately I got.
All right. For the reason stated therein, the application is allowed. Which is the order? That order so and so is recalled. Writ petition civil 19810 is restored to file. Listed with the roster bench on 11 July.
Supplementary item 4.
Maybe, sir, my lord, CMP allow.
May I please your lordship? This is for default, my lord. That is-
All right, all right. Same order here.
No, your
List
lordship, may
before the last.
your lordship, may kindly see the impugned order which has been challenged in the writ petition. If there is any merit, my lord, may can restore it. Page 21 of the writ petition, my lord, can see. The original application was filed after 14 years challenging the applied order of the district.
Anyway, that roster bench will deal with that. All right. List before the roster bench on 11 July. All right. Thank you, Justice Rock. She's coming here. Huh?
Supplementary list for admission item number 1.
May it please, my lord.
Yes, Mr. Sir.
But your lordship has now the affidavit filed on behalf of IBM. There is opposite parties 5 and 6.
Yes.
If your lordship turns straight away to paragraph 9 at foot of page 4.
Yes.
The allegations made in para 6 of the writ application are not correct and hereby denied. It's humbly submitted. There is no deliberate or malafide intention in non-implementation. That's all right, Mother. In form F1, there has been, if your lordship may be pleased to know, there has been a delay in the implementation of separate reporting of average sale price below 51% due to technical reasons. IBM is publishing ASP regularly, no issues in regard to the leaseholders as below 55.
One minute, Mr. Sir. $98.
Page
Computer page 498.
498 was there. Keyboard रे वाचलं भारी. Just scroll out.
Yes, Mr. Sir.
Your lordship has para 9.
Actually, para 7, I think, what you're reading.
Para 7 says in reply to para number 1 of the writ application, it is humbly submitted. That's how it begins. I'm reading the para commencing, opening with the words that the allegations made in para 6.
1 minute.
It was para 9.
That will be, my lord, internal page 5 of that central government affidavit.
Correct.
It starts at the foot of page 4 and then spills over to page 5.
Yes, 4 it was started, yes.
It says it is humbly submitted. There is no deliberate malafide intention in the action, non-implementation of Form 1 of the mineral rules. There has been a delay. The lordship may be pleased to mark this delay in implementation of separate reporting average sale price, so below 51%, 51 to 55 due to technical reasons. IBM is publishing the ASP regularly, no issues in this regard by any other leaseholders for below 55. FE is weighted average of all grades produced by miners. However, respondent 6 has developed online portal to file monthly returns wherein petitioner can report production and dispatch of low grade ore below 51 and 51 to 55. The online portal is fully flagged and operational now, and accordingly, IBM will publish ASP after capturing the data from the online portal from April 22. He says, thus the issue has been addressed. But the problem is,
yes,
they have not yet been able to create the prices, and that's in para 12.
Internal page 6, madam.
Para 8 also.
Internal page 6.
End of para 8 also.
Yes.
Yeah, yes. End of para 8 also. Let me read end of para 8. I'm grateful. It says the online portal is, the last 6 or 8 lines, online portal is fully flagged up. IBM will publish ASP after capturing the data from the online portal from April 2022. Now, this becomes a bit of a catch-22 because what my price is today, the problem with my prices is, if I have to pay to the state government on this basis, the price difference is such that it becomes completely unworkable. Because when we've done a calculation, what happens is the notified price is 2,687 for lumps and 1,532 for fine. My sale price is 600 and 500.
and
500.
500. It's a fraction of this price, which is fine. I mean, that's we bid for it, we got low grade ore, we are happy at this price. But if we have to pay royalty at the higher prices, and I already have 71 crores which I have paid to the government for undispatched quantity, because that quantity is still sitting with me. Because it's becoming impossible to work these. So while we are grateful that they have at least created the portal, and we are happy to put whatever dispatch figures or whatever there are in the portal, but we cannot, till they come up with a price, and we are already now they were talking of April 2022. As your lordships hear this, we are on 13th May 2022.
And still they don't have the prices.
No prices as yet, and I don't know how long the IBM is going to take.
Yes, Mr. Pari, what is the latest? Because your affidavit is now already dated.
Lordship may see the notification, latest gazette notification, that is annexed 11, page 12. It started from page 12, and my lord may come to the page 14 onwards. This is in English version is there. The notification dated 11th April 2022. From that notification has came into force after it is a fact that after reconsidering all the issue, that notification came into force, categorizing below 55%, and this is the ratio. Unless until all the bidders, those are buying, are feeded everything in the portal, then average price cannot be determined by now.
No. So that's the whole point. You have given yourself an April 22 date.
My lord.
We have well crossed April, we are now in May. So what is your estimate? When can you publish an ASP for this band, 51 to 55?
My lord, basing on that notification, we have to come after uploading in the portal. Then only we will come to what is the ASP, my lord.
No, but you have given yourself a date of April 22, Mr. Pari.
Yes, my lord. That was not been finalized because all the portal, my lord, there's a system, my lord, I'm clarifying. Unless until all the persons are not feeded, average price cannot become. So only suppose the petitioner will feed it properly, but others are not been uploaded. Then we
No, no, so
cannot.
what should the petitioner do therefore? That's the whole point.
Yes.
Should he
So
just keep?
there is a system, my lord. They have to upload it within a particular time, within a month. Then only it can be calculated and average price will be published by the particular organization. In Nagpur, the IBM office is monitoring everything. Then they are notified that what is the average price, my lord.
The time. What is the time by which time they have to upload?
That.
Lord, may I come in if your lordship don't mind?
Yes.
Kindly see the MCR 2016. The MCR 2016, and my lord, it could be, if we are holding the same book, it will be page 415. There is a rule 43.
Which page do we find this, Mr. Parija?
415, you know, if we are having the same book, otherwise it will be mineral other than atomic hydrocarbon energy mineral concession rules 2016.
I'm giving my copy. My lord, you can have.
Mr. Mudali, you can hand over here.
I have handed over my copy.
If your lordships kindly has a look at rule 43, my lord.
Yes.
The time limit is within 45 days.
Correct.
So therefore, if this is April onwards, then ideally by 15th of May, they should be in a position to give that. If your lordship sees 43, the Indian Bureau of Mines shall publish the average sale price of each mineral grade concentrate removed from the lease in a month in a state within 45 days from the due date for filing the monthly returns as required under the MCDR 1988. So, my lord, therefore, your lordship should call upon IBM. Now, this we are already into, we are close to 15th of May, by which time this 45 days window should get over. So, IBM can publish an ASP. And my lord, they have an internal mechanism of a statistical department, because here there may not be many transactions for this grade. So therefore, they have to find out some price. And on the basis of...
No, suppose we kept it for next Friday. Will by then...
My lord, that depends on really what Mr. Padi's clients can do.
My lord,
as I saw,
one line, my lord, what you may see, the mineral concession development rules 2017, rule 45. That rules provide monthly and annual returns. May is 160 is a new book in 2021 books. It is 164, page 164. If Lordship will refer the professional books, then
Lord, it's 170.
170.
169.
Yes. Monthly and annual returns.
168. Lord.
My book is 164. Lordship. It's chapter 6, notices and returns.
Right.
In let's may come to sub 45 subclass 5.
Yes.
The holder of a mining lease shall submit online returns in respect of each mine to the regional controller or any other authorized officials of the Indian Bureau of Mines in the following manner, namely, by which they have to submit the return within 45, basing on the rule 45, and basing on which what my land Advocate General has submitted, then we will come to the notified the SEP.
Look at 5B.
Now, basing on new notification, definitely the SP will determined by the IBM.
Look at 5B, 45 5B.
My lord.
A monthly return which shall be submitted before the 10th day of every month in respect to the preceding month.
Yes, ma'am.
So once you get it by the 10th, you should have got to April 1 by 10th of May.
Yes, yes. Right, Lordship, I'm just.
Now you get it by 10th of May, then 43 kicks in. Then 45 days from the due date.
Due date. Yes, yes. That's why I meant that.
So that will take you far beyond May 15th.
Yes, yes. Because why it is, my lord? This all have to feed it the system. Then only from that system, that source of returns, we have to come a average. Then only it may be notified by the IBM. Then Larcime that B subclass I Larcime C for all minerals except the copper, gold. These are the excluded, and the iron is the minerals.
Yes, Mr. Salve, so what do we do?
Yes, my lord. We are now, please see where we are, if you're not to consider. Under the rule, I have to pay as per the IBM. And the
Right.
IBM now acknowledges it doesn't have a price.
Right.
So the only way is I'm going to suggest I will keep mining so that my dispatch, my production obligations are met. I will store the ore, I will not dispatch it, but I can't be asked to pay at 15 at the, when admittedly now there is a price band which should apply to me, but which is blank. I can't be asked to pay on a higher price. So it's not my fault. There is this problem which has come about. I will produce, I will store, the ore is not going anywhere. I will keep the ore with myself.
No, this is only till first time they publish the ASP.
The day, my lord, they publish, I want to sell because for us, it's a cash flow issue.
Right.
If I don't sell, I'm not spending on raising the ore.
Mr. Padu, therefore, definitely by July, you should be publishing the ASP.
Probably, yes, my lord, definitely.
Because 45 days will take you
yes.
end of June, right?
End of June.
End of June. So, yes, July, we should have the ASP.
Yes. Definitely, because after the new notification, they have to. Because
Not for
there
that.
is no system.
Not for
Now
that.
the system is introduced, my lord. This, after gazette notification, we have to do this.
But for that, the petitioner has to sell, because unless he sells, there can't be no, there cannot be any ASP, because IBM.
No, they've already sold in April.
Yes, yes.
April, they've already sold. They filed returns by 10th of May. So we will know an ASP 45 days from 10th of May. That's how the rule works. No, April they must have. April you must have made sales.
Before. My lord, we have filed the sale proofs, my lord, in flag D.
That's right. So April they've sold.
May I pray, my lord? Let's make
Yes.
After some days, then I will take the proper instruction from the department itself. What actually after the new notification, what development actually we don't know. This notification, gazette notification came into force on April 2020.
No. If you make a categorical statement when you will publish the ASP, now that you refer to all the rules.
Instruction I don't have, my lord. But
No. So we'll keep it next Friday for you to make that statement.
And may I suggest, my lord, in the meanwhile,
Yes.
I will also make over to my we will make over to my learned friend. He can pass them on the invoices which we have for our sale.
Right.
Let them have a look.
Correct.
And at least if provisionally they notify that price, we can start moving. If later on they find a higher price, they can revise it.
Correct.
That's fair.
So that we have some workable mechanism.
And at 7 days, nothing. Let me, I take instruction.
No, you can take this information also and give it to IBM.
Yes. I will take the instruction definitely for IBM.
All right. You say, Mr. Padi, learned counsel appearing for the IBM, seeks time for instructions on the approximate date on which the ASP for iron ore below 51% Fe will be published by them in terms of rule 45 bracket 5 bracket small b of the Mineral Conservation and Development Rules 2017, read with rule 43 of the minerals bracket other than atomic and hydrocarbons energy minerals bracket concession rules 2016. Mr. Salve, learned senior counsel for the applicant / petitioner, states that the petitioner will provide, the counsel for the petitioner will provide Mr. Padi with the sample invoices of the sales effected during April.
My lord, I don't think so. We have made any sales in April, my lord. We have given invoices of last year, my lord.
Okay.
Payment that we have made. We have already annexed.
We'll give him those invoices, my lord, whatever we have.
Sample invoices of the sales made to enable the IBM to come to a decision in this matter. Is permitted to do so. List next Friday?
Yes, ma'am.
Gotcha, please.
All right, list next Friday.
That's my
20th.
report. Along with me, Mr. B. Maharana is appearing.
Yes.
Village.
Pronouncement. Oh, is there a pronouncement or? Which of these lists?
Lordship. Here the petitioner filed IA, my lord, but his criminal appeal dismissed, my lord. They're directing him to surrender before the court below within 10 days. This is filed on the 16th, my lord. In the meantime, he has applied for the certified copy, but he has not obtained. In the meantime, what happened? The lordship is only son has met with a serious accident, my lord. Or he is now in coma.
Tomorrow we list it. List it tomorrow.
I may pardon to mention, this is a matter pertaining to your lordship's this Prawanagiri demolition case, lordship. I have 100 number of coconut trees. My dwelling house are there. I am giving undertaking that from today onwards and in future also, I will not do any kind of prawn cultivation. That additional affidavit I have filed today. I have sought the copy also London Council appearing for the state lordship. Your lordship may kindly taken up this matter on Monday or Monday. Lordship.
Tomorrow, Monday.
Monday, lordship.
Tomorrow there is no. Yeah.
Item number 1, sir.
My lord.
For orders, item number 1.
My lord, due to failure of link, I could not appear to virtual. Your lordship,
for the reason stated, the order is recalled, the application is allowed. List before the roster bench.
I am appearing on the 2 and 3.
On 11th.
My lord, this is entry tax matter. Item number 1 and 3. This may be connected with the WPC number 13736 of 2017.
Okay. 13736.
All right.
All these three matters.
No, my lord, item number 1 and 2.
1
and 3, my lord. Regarding second matter is GST interest matter already covered, my lord.
All right. 1 and 3 you see list along with that other writ petition. When are those writ petitions coming up? Entry tax?
Not at fixed, my lord. Your losses may take up after vacation.
Mr. Chimanga, is it covered? The second matter?
Yes, my lord. Second matter is covered by your lordship's order.
No. Who's appearing in that?
Mr. Chimanga.
Mr. Chimanga.
Let CMP be passed. It will listed 10277 or 200. It is not a covered matter. Let it be listed, my lord.
All right. Recalled list before the roster bench on 11 July. Right.
For admission, item number 4.
May I please, your lordship? On behalf of Devashish Tripathi, my lord, last occasion your lordship directed to the opposite party number 4 to submit a report, my lord.
Last 2 occasions, lordship have been pleased to grant us time, my lord. One last time will be given, my lord.
All right. Last opportunity is granted to the opposite parties to submit the report before the next date, 18th July.
Item number 5.
Obliged, my lord.
My lord, I am in VC, my lord. In this case, last occasion, the lordship was directed to take instruction. So far, the month of March and April, he has to file the affidavit, so that they can.
Yes. No. Here the allegation is that there
Power
are
cut.
regular power disconnection,
Yes,
power disruption.
Power
And
cut, I have given the
petitioner was saying that from 6 p.m. to 6 a.m. every day, every night the power has been disconnected. Now the lordship directed the TPNODL, the council for the TPNODL, to file an affidavit
on month wise, my lord. In fact, we will also directed for month of April.
Where is that affidavit?
He has filed it, my lord.
Yes,
March and April they have filed.
Sorry?
March and April only they have filed.
So
what else? March and April we will file.
Yes, ma'am.
Yes, I have filed for 2 months. Your lord, as per your lordship's direction, we have filed.
What more do you want? Counsel with the petitioner, what more do you want?
In this case, after filing of the writ application, before that 6 p.m. to 6 a.m. they are disconnecting. After filing of the writ application and the direction of this honorable court, now your lordship may kindly have a glance the affidavit they have filed along with the monthly report. 6 hours, 7 hours, 5 hours they are disconnecting powers of in the night. How the people will survive, my lord? 7 hours they are disconnecting. Kindly have a glance the affidavit they have filed for the month of March and April.
So far as
In April, it's come down to 2 hours.
Yes, my lord. After
So what? 2 hours is more places. 2 hours is not extraordinary. 2 hours is not extraordinary, sir, in a whole day.
86 villages, whole day, daytime also they are disconnecting. And heavy summer is there, my lord. Now the Kanjar district of lordship will find there is no rain at all.
No, my lord, the stand of the assistant conservation forest is, my lord, whenever there is an information that the
elephant movement.
So at that point of time, they only request the TPNODL to disconnect the power.
Correct.
Otherwise, my lord,
they are
every day, there is every day.
Every day, my lord.
Elephant movement is there every day.
Yes.
No, my lord.
Yes.
But every day they are disconnecting.
Most dates, specific dates have been given, and there are.
It's almost on a daily basis, sir. Elephant movement is on a daily basis.
No, my lord. Absolutely false.
It's a jungle area. My respectful submission is, in most days, as per the affidavit I have filed, my lord.
No, I think you give us the details of the information you're getting from the wildlife department.
Information is mostly given on telephone. That has been recorded here. I have submitted the extract of the. That is not disputed, but the only difficulty is there is a elephant corridor in order to sort out all these problems and the problem of power cut. There is a elephant corridor, and that program is going on, and in war-fitting manner, the government has allotted, and that has been upgrading, making height of the electric lines. So whenever it will be completed, the problems will be sorted out. That is the.
How the people will
That
survive, my lord.
Sir, we can't go on arguing. If you want, we'll put it for final hearing on Sunday.
Oblige, my lord. And
List on August.
I will file rejoinder, my lord, in this.
All right. Rejoinder will be filed before the next date. List on 1st August. Yes. All right.
Oblige, my lord.
All right, sir. Thank you.
Reference. Output is.
Good afternoon, sir.
Supplementary list for admission, item number 1.
Miller, that extra set requires Miller, I have filed today, Miller. The ombudsman is the OP number 1. So for 2 you can
04 of 2001 will be listed before the roster bench on 18th May. Let's finish it now. 18th May. Yes, right.
Appearance, we are appearing for LA.
Yeah.